Hi, everyone. Good evening. Carl Steinbeck here. It's been quite the day. Day 16 here for the Massachusetts versus Karen Reed, otherwise known as Commonwealth versus Karen Reed. And today is an awesome day for the defense. It's pretty much game over for the prosecution. Their case is crumbling before them. As I've been saying in the days previous, we didn't hear from the medical examiner. We didn't even think Hank Brennan was going to call the medical examiner that originally did the autopsy on John O'Keefe because she didn't fit the narrative that Hank Brennan and Morrissey wanted. So they had to flip the script as much as they could. And he decided to go ahead and call her because I think it might be because there's so many people talking about how he's hiding the ball, keeping the truth out. So I think he decided to bite the bullet, bring her on as a witness. And wow, did the government's theory get slaughtered today? We also had something happen after the end of the testimony about a motion that the defense raised, so we'll get to that as well. But the point is, we had just devastating impacts on the prosecution's case today because their own medical examiner basically couldn't even declare this a homicide. So she couldn't explain how the manner of death was. If you don't have manner of death and it doesn't fit a car accident, a car strike on John O'Keefe, and guess what? They have no case. And that's why, remember, we've been hearing all this little snippets of video of Karen Reed talking to media. That's all Hank would try to do is play these little snippets to try to get the jury to dislike her because he's got no science. And keep in mind his opening, he talked about science and facts and data and things of that nature. And all that points to Karen's innocence. So it's really just amazing to sit back and watch this train wreck embarrassment for somebody that's an experienced attorney to go in there and take this case. I've never seen an attorney that's willing to basically embarrass themselves to this degree. And then the judge is going along right side of it and just embarrassing herself as well with these horrendous, horrible rulings, outward forms of bias and prejudice against Karen and her defense team. So you just can't believe it. And I've seen some of the comments here. You guys are saying I'm gonna need our emotional therapy cat Leo to come in here because I'm gonna get pretty mad. But yeah, it just really burns me when I see prosecutors resorting to tricks and deception and schemes to bamboozle and trick the jury from not seeing the truth for what it is. So whenever you have to do that as a prosecutor, you're not a good prosecutor. You're basically failing the mission. You're failing the public. You're supposed to be trustworthy. You're supposed to be above board. And when you resort to tricks and trial by ambush kind of things, and basically it's everything that he's saying the defense is doing is what he's doing. So that's really I guess what you'd expect for somebody that's used to dealing with the mob. So anyway, I'm going to go ahead. We saw this morning initially, we saw the continuation of Maureen Hartnett. She was a state lab forensic science lady. So I'm not even going to cover that at all. It's not worth getting into. We need to get right into the medical examiner heavy duty stuff here. So let me go ahead and get started on that. So the cross started here about 3 hours into the session this morning. So here we go.
May I, Your Honor?
Yes.
We have not had the pleasure of meeting, so good morning, Dr. Scordi-Bello.
Morning.
With regard to cause of death as opposed to manner of death, is it correct that a forensic pathologist is tasked with determining that cause of death that includes contributing factors, injuries, and circumstances regarding the medical legal death investigation? Is that a fair statement?
Yes.
And I'm using the term medical legal. Is that a term that you're familiar with?
Yes.
And is it correct that medical legal means, particularly for medical examiners, that there's a medical aspect to the investigation that you perform, and there's also a legal aspect or a law enforcement aspect to it. Is that correct?
Correct.
And that's a little different than what physicians usually do, right? Because isn't it the ordinary course that it's mostly just medical, but medical examiners by statute and law need to have both of those prongs taken into consideration. Do I have that right?
Yes.
So in other words, the forensic pathologist, which you've indicated you are, is tasked with determining the cause of death, which answers the question as to why, in more layman's terms, why did the individual's body stop functioning at a particular time, correct?
Yes.
So more broadly, the cause of death is generally defined as the disease or the injury that resulted in the death of a person.
Correct.
So let's now, if we could please, move to the manner of death. And I'd like to summarize, I know you covered it on direct, but I want to put it in a slightly different context, and hopefully I'll get it right. So medical examiners, as you've stated, are also tasked with, if they can, determining the manner of death or the circumstances under which the death occurred, correct?
Correct.
So manner can and does involve the circumstances under which the death occurred.
Yes.
And that causes one to go a little, the medical examiner to go beyond just medical analysis. You take into consideration other factors, which we'll get to. Is that correct?
Yes.
So you talked about, and I'm just going to go through them quickly, but if you could just check me on this, the 5 main categories of manner of death. So you talked about natural causes, correct?
Yes.
You talked about accident.
Correct.
You talked about suicide. You talked about homicide. And then the last category, undetermined. Do I have that correct?
Yes, you do.
So what I'd like to do is to focus on the undetermined category. And my understanding is, doctor, that that's where you landed, that's where you concluded with regard to manner of death of Mr. O'Keefe, correct?
Correct.
So undetermined is a term that is used and that you use. And does that mean that when the information pointing to one manner is not more compelling than other reasonable possibilities, or the death investigation lacks sufficient information to opine on a manner of death, at the time of death, the certificate is signed? Is that generally correct?
Yes.
So as we've talked about, I'm just trying to follow or just develop some logic and see if this is in agreement with you, that as a medical examiner, you're specifically tasked with this, conducting that medical legal investigation. And what we've just talked about is a bit of the method of analysis that you go through for that, correct?
I conduct the autopsy and I request information information from the investigative body that is out there investigating the other aspect of the case, not the body itself.
Yes. So is it correct that there's 4 general components to a forensic pathologist?
The jury saw what this doctor said. It's this horrendous as a prosecutor to have somebody like this called a witness. You don't see a prosecutor calling a witness that torpedoes her case this bad, okay? This is an expert. This is a medical examiner. She's the one that's the best one to say how John O'Keefe was killed. And the prosecutor didn't want to call her. He's been burying her among witnesses. He finally decided he had to call her. Otherwise, it's too obvious he's hiding the ball and everything. He's objecting to all the truth coming out for the last 15 days. So now he calls her on the 16th day. So no matter what they're trying to do to change the timeline and all this and change their expert opinion to try to counter ARCA and all this garbage and try to align with Ian Whiffen. And anyway, it's all the truth is going to come out in the end. It's already come out. And once you got this kind of momentum, I don't think that the prosecution can ever recover. So that's the good thing about it. The truth is going to come out here and continue to come out so they can try to put a spin on all their other witnesses. It's not going to matter because in the end, the truth is going to come out and there'll be a not guilty vote across the board.
Pathologist death investigation. Is scene investigation one of the components?
It depends on the jurisdiction where you practice. Scene investigation is part of forensic pathology in certain jurisdictions, and it is the responsibility of the district attorney and law enforcement in other jurisdictions. In the state of Massachusetts, we are responsible for the autopsy, and the DA's office and law enforcement are responsible for the scene investigation.
Excellent. So scene investigation in the state of Massachusetts is not within your domain in the office of the medical examiner. That is the domain of the district attorney and law enforcement, correct?
Correct.
How about another aspect, forensic autopsy and laboratory testing? That's within your domain, correct?
Correct.
And how about police reports and witness statements?
That is not under my jurisdiction. That is under the district attorney's office and the police.
Do you consider information, nonetheless, from police reports and witness statements in your analysis?
Yes.
And do you also consider, even though it's not within your jurisdiction in Massachusetts, do you also consider information about scene investigation?
Yes.
So it's correct then that you consider, whether it's within your jurisdiction or not, you consider scene investigation and police reports and medical statements, correct?
Yes.
And then
I hope the FBI is doing wiretaps on Canoni's phone, her and Morrissey's.
forensic autopsy and laboratory testing is right within your jurisdiction, and therefore, of course, you consider that. And then lastly, medical history and hospital records, is it therefore, am I correct that that's something within your jurisdiction and that you consider in performing your forensic pathologist death investigation?
Yes.
So now let's move on to the application of those principles. So in order to conduct a proper medical legal investigation, the medical examiner has to have certain qualities, if you will. Is one of them being well-grounded in general medical knowledge?
Yes.
Is another appropriate training and experience in forensic pathology?
Yes.
In other words, you wouldn't want a specialist, for example, in cardiology without anything more to be conducting a death investigation. Is that correct?
I would not want them to be conducting an autopsy. Correct.
Right. Would you want a neurologist to conduct a death investigation?
Personally, or are you asking me that? No, I don't think every physician has their specialty and their training.
So this is a smart move by the defense. They're using the prosecution's own witness to discredit the other upcoming witnesses, that neurologist from Miami that Hank's going to try to use to explain some kind of car crash, I guess, killed.
And forensic pathologists are trained to perform autopsies, and cardiac surgeons are trained to perform cardiac surgery.
I'm not seeing.
Would you want a neurosurgeon to be conducting a death investigation?
To be performing an autopsy? No.
So you wouldn't want a neurosurgeon to perform an autopsy?
No.
Because you don't believe they're qualified to do so, correct?
I don't believe they've had the appropriate training to perform an autopsy.
You hear that? So this upcoming neurosurgeon that Hank is going to rely upon to try to prove his case beyond reasonable doubt, Dr. Scordi-Bello is saying that they don't have the training experience to even be qualified to talk about that.
Going back into the many qualities of a medical examiner and attributes, they also have to have the ability to form opinions based upon all the available information using the scientific method along with sound reasoning. Is that a fair statement?
Yes.
And you're familiar with the term scientific method?
Yes.
And is it fair to say that the scientific method generally is sort of a systematic pursuit of knowledge that involves recognition and definition of a problem? Is that fair?
Yes.
Is it also involve the collection of data through observation and experimentation where appropriate?
Correct.
Does the scientific method also include the analysis of data?
Yes.
Does the scientific method also include the formulation, evaluation, and testing of hypotheses?
Yes.
And does it also, where possible, include the selection of a final hypothesis after considering other hypotheses?
Correct.
So what we've just discussed is a fair explication, a fair explanation of the scientific method. And the
Correct.
scientific method is part of the autopsy and forensic pathology analysis, correct?
Correct.
Now, applying one concept, that medical legal concept we talked about, just holding for a moment, if you could, the medical and going to the legal, if you will, law enforcement that you said in Massachusetts is not under your jurisdiction, but nonetheless, you consider information arising from it.
Yes.
Are you familiar with?
Yeah. Hank thinks he can outslick this jury and trick them into believing things about the case because he's got a judge that is in his corner. But I think when the jury gets a sense of how things are going and they can see the prosecutor is always objecting, he's the one objecting. He's not the one trying to block good questions coming out. The jury can see that the defense is asking good questions and the prosecutor's always there to like nip them at the heels, try to cut them off. And this judge is pretty much every single time back in the prosecution. So if the jury is not smart to figure that out, then there is no hope in Massachusetts ever.
A person named Michael Proctor. Is that name familiar to you?
Yes, it is.
And at one time, Michael Proctor was a trooper, correct?
Correct.
And so did former Trooper Proctor inform you of the working law enforcement theory at the time of the investigation of this matter, namely his working theory, a collision of a motor vehicle with a pedestrian? Did he inform you of that?
He informed our office of that. Yes.
He informed your office. And is it fair to say that he informed your office or provided that?
I'd be calling the judge out to recuse due to a conflict, hostility, bias, prejudice, interactions every single day on the record. I don't know what they're doing, but
That information to your office in or about February of 2022?
That information, part of that information was provided to our office at the time of the autopsy. One of the pieces of information that had come in, and there were multiple sources calling into our office, providing information, was that this was a possible person struck by a motor vehicle.
And the time of the autopsy, if I have it correctly, was that around the end of January of 2022?
The autopsy was January 31st.
Your Honor, if I could, with your permission, please publish a photograph which Your Honor has and the parties have stipulated, or that's in evidence. And this is the one. May I approach, Your Honor?
Yes,
May I show that to the witness?
okay. All right, so we will mark this as the next exhibit. There's no objections to Brennan?
No objection.
Okay, so we'll mark it first and then you can display it.
Thank you, Your Honor.
Exhibit 100.
it's like they're working for the same boss.
Thank you.
Yep.
May I, Your Honor?
Yes.
Thank you. Dr.
Major
Scordi-Bello,
backfire
if I could
today.
Hand that to you, please. You could take a look at it, and when you've had a fair opportunity to look at it, you can just look back up, and I'll proceed at that time.
Yes, I recognize the picture. Well, I've never seen this picture before, but I know what it's depicting.
Thank you. What is depicted in that picture?
It's a picture of two individuals standing in a morgue setting, which looks very similar to our morgue at the Cape Cod office.
Very good. If you could just hold that for a moment, and with the court's permission, could
The only one that's going to go after rooting out corruption up there is the feds. The state is not going to police itself. They're allowing this to go on. All this kind of stuff is tied to the political connections of Morrissey. So Morrissey's going to be there still a while as a district attorney, and until he gets ousted in the next election, I mean, even then, it's part of the same party. So I don't see anything changing there for a long time.
I publish that for the jury?
Okay.
Thank you. Mr. Wolf? And if you could please zoom in on the two individuals in that picture. Dr. Scordi-Bello, do you recognize any of the individuals in that picture?
To be perfectly honest, no, I don't.
With regard to the person on the right, do you recognize that person?
No, I don't.
And you said you recognize the setting, correct?
Yes,
And you, if I heard you correctly, you said this is the Cape Cod facility?
it appears to be correct.
Right. So you testified earlier, if I recall correctly, that the autopsy was performed at the Cape Cod facility of the Office of the Chief Medical Examiner.
Yes, it was.
And you're normally in, as I recall, the Westfield, in an office that covers Western Massachusetts, it's Westfield.
Correct.
But you were at the Cape Cod facility, as I understand it, because there was a staff shortage and you had to travel down to Cape Cod for this. Is this correct?
Correct.
So you weren't at your normal home base sort of facility. This is a facility that you went to for this autopsy, correct?
For this autopsy and multiple others, yes.
Yes. And you were covering a staff shortage, and that was the reason you
They're
went
not
to
showing
Cape
what's on
Cod,
the
correct?
screen.
Correct.
And what's depicted in this picture are two individuals. For two individuals to be present, is there a protocol that they had to follow to be?
Some of the autopsy photos are not shown on the screen. Here we got Trooper Keefe that we heard from earlier in this case, and there's somebody else with him. I don't think that's Trooper Proctor, but remember, Keefe said that he was there alone representing the state police. So here we show a photo, and there's two troopers there. So another inconsistent statement from somebody on the Commonwealth side.
Present for that, like a sign in or an authorization?
Yes, there is a sign-in sheet that individuals have to put their name and their shield number and before they can come into the autopsy room.
So they have to put a shield number down, correct? You mentioned a shield number.
Yes,
And does that therefore mean that even though you don't know who they are, that they are with law enforcement? Are you able to determine that?
correct. I believe they were with law enforcement.
So those two individuals were with law enforcement, but you don't know who
I
they
know-
are.
I don't know who they are.
They're not switching it because of the medical examiner reports and ARCA. I think they knew this was in the works, and so I think he's just realizing he's losing the case, so he's trying to do more smear bombing of Karen's character by bringing in the Aruba situation. So I don't think there's really that much of a change per se. I think it does show desperation. I think Hank has figured out the writing's on the wall, and he's in full-on desperation mode and panic mode.
Specifically and what their actual position was.
But they were with law enforcement.
I believe, if my memory serves me right, there was a person from crime scene investigation and someone from state police.
Thank
But I'm working on a 2+ year memory.
Fair, that's fair, that's fair. I'm not going to ask you more questions to probe the memory. We can take that down. And
Sarah Turnbull, you're asking what happened to me, or am I just writing a tide of conspiracy theorists? What about common sense and defendant's own word? Well, I guess I've been around criminal law cases for most of my adult life as a lawyer. So I'm going on my 35th year. And of all the years I've done criminal work, either as a prosecutor's defense counsel and rotated different jobs, I can tell you that the my impressions and instincts are well honed, and I can tell you that from when the time I looked at this case, it just didn't have the kind of physical forensic type evidence. And if the only thing you're looking at is Karen's own words, well, she was the other to influence that night. Okay, so I don't know if you've never drank alcohol before, but drinking alcohol can make you say and do things that are not consistent with your normal character. So if you're going by her own words when she was somewhat inebriated that night, then I guess you're the one that I would say doesn't have the experience to be able to read this. And I guess you're telling the first jurors from the jury of trial one that they don't have any common sense either, because there was a unanimous vote of not guilty for murder. So I don't know which charge you're talking about, if you're talking about all of them here or whatever. But the if you all you're looking at is Karen's words, then then I guess what you're doing is falling into the trap that Hank Brennan is trying to set for the jurors. So that's all I got to say about it. So it's not a conspiracy theory. This witness alone proves that they don't have any case. There's no physical forensic evidence. So she could jump up and down and run around the scene saying, "Hey, I did it. Arrest me," which didn't happen, obviously. And what happens is you got to have corroboration to a confession. This wasn't a corroboration type confession here by any of the evidence we have from the state so far. And so she says, "I hit him." Well, what did she hit him with? What are you saying she hit him with? A vehicle? Hit him with a fist? So no, there's no follow up to that. That's not a true confession of the sorts. And there has to be corroboration for a conviction to stick if there is a confession. So there's no corroboration here because the physical evidence and forensic physics type evidence makes it go the other way, which is he got killed by other means. So you're telling me Karen also chewed on his arm to give him dog bites? I mean, come on, this is ridiculous.
And yeah, we are finished with that. If you could hand that to thank you. Now, we were speaking about former Trooper Proctor. Do you recall former Trooper Proctor sending you a copy of scene photographs and wanting to schedule a phone call with you so that he could explain the status of his investigation? Do you recall that?
Yes.
And that occurred approximately in March of 2022?
Yes, approximately.
Right. And the method of communication of that was that by email, to the best of your recollection?
I requested that our medical legal investigator, we have our own investigators at the office that are responsible for obtaining medical records and sometimes being the liaison between us and law enforcement to get reports. I requested that she contact whoever was in charge of the investigation and set up a meeting, a phone call. So since it had already been a few weeks since the autopsy, I wanted to make sure that if there was any additional information that could be provided to me, I could take it into account because I had 90 days to issue a report and a death certificate on this case.
Now, you've mentioned the 90 days on direct. You just mentioned it now. Is the 90 days a hard and fast rule, or is it just something you aspire to as a matter of good practices?
It's not a hard and fast rule. It's something that as an office, we try to achieve. Again, the reason being that there are family members, next of kin that are waiting for these reports and these death certificates for various reasons. So is it possible to go over the 90 days? Absolutely, if necessary. But we do try to finish our part in those 90 days.
So it's possible to go past the 90 days, but there would given the considerations you just articulated, there has to be a pretty good reason why you'd want to do that, right?
Correct.
And in this situation, you concluded that you had sufficient information on the medical side and the legal side to come to the conclusions that you needed to come to. Is that fair?
Well, I had sufficient information on the medical side because I did the autopsy and I had those findings. I did not have sufficient information that pointed to one manner of death over another manner of death. And therefore, I stated that the manner of death was undetermined.
Exactly. So the manner of death is undetermined. And I want to, if I could, with you, pursue that a little bit in a moment. But when you came to, toward the end of that 90-day period, you had information from the law enforcement side on their theory of what had happened, correct?
Correct.
I'll let that one stand.
You had performed all of the medical investigation and analysis that you needed to perform, is that correct?
Yes.
There wasn't something more that you wanted to do on the medical side. You had mentioned, to be fair, you had Dr. Stonebridge involved as well. You had what you needed on that side, correct?
Yes.
I think it's so pervasive the way this judge is coming across, her hatred. The jury should be able to pick up on it and see that there's something really off with this judge.
And you therefore concluded on the manner of death that there was a not more compelling or more likely than other reasonable possibilities. Is that fair?
Yes.
So in furtherance of that, on April 14th of 2022, you issued a death certificate, correct?
Yes.
And please feel free to check your report of any dates or any other particular as I go through.
Okay. I issued my final report on April 14th, correct. And I would assume that the death certificate was on or around that same day.
Thank you. Now, to back up a little bit with regard to the autopsy, as you stated, it was conducted, I just want to do a little bit of a timeline, on January 31st of 2022, correct?
Yes.
And we discussed that the body of Mr. O'Keefe was presented to the Cape Cod location, correct?
Yes.
And you also discussed that you brought Dr. Stonebridge to work with you on this matter, correct?
She didn't physically come to the office. The way Dr. Stonebridge was involved is at the time of autopsy, when the brain was removed, having seen that there were injuries, I saved the brain in a special solution, and then the brain was transported to our facility in Boston. That's where Dr. Stonebridge examines the specimens. And after examining the brain, she issued a report.
Who asked Dr. Stonebridge to become involved in the matter?
I did.
And Dr. Stonebridge is triple board certified, correct?
Correct.
She's a forensic pathologist, correct?
Yes.
That means she's achieved board certification in forensic pathology like you?
Do you know that?
I do.
I'll allow that.
Yes, she is board certified in forensic pathology.
And she is board certified in general pathology, correct?
Yes.
And she's board certified in neuropathology, correct?
Correct.
Can you briefly describe to the jury what
Smile.
neuropathology is?
Neuropathology is a subset or specific additional training in forensic pathology where the person spends a considerable amount of time, usually 1 to 2 years, examining brains and learning all about the diseases of the brain as well as trauma to the brain.
Now, you asked her to be involved, as you indicated earlier, correct?
Yes,
And you determined that she should be involved because there was a brain injury, correct?
there was trauma to the brain, correct?
Trauma to the brain. Is it a fair characterization that Dr. Stonebridge is sort of the brains of the brain area of autopsy? Is that fair?
I'm going to sustain the objection. Let's move on.
So with regard to Dr. Stonebridge, would you agree that she's really uniquely qualified in some ways? Or how would you describe her qualifications, Dr. Stonebridge?
Sustained.
With
already got it
regard
out.
to Dr. Stonebridge,
So he wants to use the good things of Dr. Stonebridge to bolster defense's point, and she's already established how uniquely qualified she is. So that's going to be a good move here to already get that out in front of the jury that a neurosurgeon is not the same thing as what she has for qualifications to discuss the cause of death. And also Dr. Stonebridge is eminently qualified as well.
what did she do?
I'm going to see you at sidebar on this, please.
So the judge doesn't like it. He's making good points, and so there you have it. Always calling cyber, cutting off the defense. All right, let me jump ahead here. So we got rid of Sarah. Oh, sorry, I'm not forwarding it here. Can't tell if it's forwarding here. What's going on? Right. That's one thing I don't like is a client that's actively looking like a lawyer on the case. When I'm doing criminal cases, criminal defense work, I do not have my client acting like they're in charge of anything. If they don't want to tell me something, they're not going to whisper in my ear. They're going to pass me a little note, and it better be limited and few, and it better be something that can't wait till a break. And I wouldn't have my client going up to the sidebars and stuff like that. They just got to sit there and look innocent and alone, and it's a good time to sort of bond with the jury. So I don't understand why they're doing this, and so anyway, that's their preference, but I don't think it's as good of leaves a good impression on the jury. But needless to say, this is this slam dunk win for the defense. So.
May I, Your Honor?
Yes.
Thank you. Dr. Scordi-Bello, have you, are you aware of an attorney name, or excuse me, a doctor named Azik Wolf?
No, I'm not.
Now I'd like to move on to another category. Based on the information.
And you could always have the governor of Massachusetts say, shut this case down, move to dismiss, but they're not going to do that. Nobody has the backbone to shut this down, and they're all part of the same party.
That was presented to you as part of your examination and analysis. Is it correct that you presume that because Mr. O'Keefe's body was found in the snow and his body temperature was 80 degrees, that he died from hypothermia as one of the causes?
I reached that conclusion after performing the autopsy and after seeing some findings that were consistent with hypothermia, and then combined with the information that was provided to me about Mr. O'Keefe's body being found in the snow, I came to the conclusion that was one of the things that contributed.
Did you consider whether there may have been other reasons as to why his body reached that temperature of 80 degrees? Sort of applying the scientific method and seeing if there were other reasons?
Other than being out in the snow? No, I do not.
Do you know whether there are other alternative reasons how his body could reach the temperature of 80 degrees?
People can become hypothermic for other reasons, such as sepsis. But in this particular case, I didn't have any reason to believe that that was part of the circumstances.
You're familiar with the medical phrase differential diagnosis, correct?
Yes,
And a differential diagnosis is a term that's used by doctors to pursue other potential causes of a medical injury. Is that a fair general statement?
yes.
So, for example, if somebody is having difficulty breathing,
Yeah, if the state goes after him, or the feds could go after the killers right now, they don't need to wait until Cairns is over. It's a separate sovereign. There's no double jeopardy, as we call it here in the United States. The feds can go after the exact same underlying crime that was committed as the state can. So feds in the state can do dual tracking prosecutions. Normally, they wait till one is done before the other one proceeds.
doctor may say, I think it's the heart is their primary hypothesis, but they may want to differentially diagnose this and look at the lungs. Is that an example of a differential diagnosis let's look at the lungs to see if that may be the problem? Is that a good, fair example?
In the example you're giving, yes.
So applying that concept, and do you believe the concept of, applying that concept to this situation, did you perform a differential diagnosis as to the cause of the death and question whether there was hypothermia as any cause of the death of the decedent? Did you make that analysis?
I looked at the anatomic findings that I had at the time of autopsy, the information that was provided to me based on the circumstances and where the body was found. And I came to the conclusion that there were hypothermic changes in Mr. O'Keefe's body.
So you just used the phrase hypothermic changes. Did I hear that correctly?
Yes,
Can there be hypothermic changes without a cause of death being hypothermia?
yes, of course.
So you can have signs in the body of hypothermia, but you can also conclude that a cause of death is not from hypothermia, correct?
If the person is deceased and I am examining the body and there are multiple things that I believe contribute to the death, then I tend to include all of them. Meaning that if this was a drug intoxication and the body also showed signs of hypothermia, I would include both of them on the death certificate because there is no scientific way of teasing out whether it was just one or the other or both. In this particular case, I had two processes that were going on. One was the head trauma, and the other one were these hypothermic changes. I put all that together, and again, included or took into account the investigative information of where the body was found, what the temperature was when the body was found, whether the person was still alive or not. And I came to the conclusion that the cause of death was blunt impact injuries of head. And I included the hypothermia because I saw.
Yes, that would be the feds moving in on that because you're not going to get justice with the state level prosecutors on up the chain. So that would be nice, wouldn't it, if that was going on, if we saw some arrests here in the near future?
During the autopsy, that there were changes consistent with hypothermia.
So I want to break that down a little bit, if I could, with you. So you testified on direct, and I think you alluded to it here, that the primary cause of death, use that phraseology on direct, was blunt force injury. Is that correct?
Blunt impact injuries to the head, yes.
Blunt impact injuries to the head, and that's the primary cause, right?
Correct.
And then there's, and I'm not clear on what you referred to on direct as a secondary cause of death of hypothermia, but you used a little different phrase in some of your answers, and I want to make sure I got it right. Hypothermic considerations. Can you repeat what it was?
I said have hypothermic changes.
Hypothermic changes, and we agree that you can have hypothermic changes without a conclusion of hypothermia, correct?
No, hypothermic changes are what I'm referring to are actual things that I can see in the organs that are consistent with hypothermia. They're anatomic findings. They're things I can see with my eyes.
So you can, I'm sorry, did you finish?
And those changes suggest and are consistent with someone being hypothermic.
As you sit here now, with regard to, you use the phraseology consistent with hypothermia, signs of hypothermia, that's what I want to pursue just a little bit with regard to further information. We got started on this by asking whether you used the concept of differential diagnosis and hypotheses to determine the cause and manner of death.
Yeah, that's a good point, Jill. You're saying if the juror complained about Paul O'Keefe looking at Karen, the dirty looks and stares he's given her, they're seeing Bev's attitude towards the defense. Yeah, I think the fact the judge didn't pick up on that and the jurors had to say something, I think that's a good sign also. The jury members are tracking all the chaos going on there and denial of justice.
And you said in one of your answers that you relied upon law enforcement information, correct? Is that
Yes.
part of it? It was, you brought that up. You're the one who said you relied upon that, correct?
Yes.
And you've brought that up on your direct testimony and earlier in the cross. Is that correct, that you relied upon the investigation of law enforcement? So
Sustained.
So now what I'd like to do is to ask you whether, using the concepts of differential diagnosis, scientific method, did you consider whether Mr. O'Keefe could have died somewhere other than where the body was found and been moved and placed in the snow? Did you consider that?
Sustained.
May we approach your Honor?
How is that not admissible? This is like so standard cross-examination, she was fed everything that Proctor wanted her to believe about the case, and Proctor thought he had it in the bag, where they're going to say a vehicle strike is what killed John O'Keefe. But she's not corrupted by this process that the troopers try to tell her, this is the way it really went down, doctor. So for this, any alternate theory to not be discussed by the medical examiner on causation of death is so corrupt. And keep in mind, this is why Morrissey hired Hank Brennan, to make sure Karen Reed's given a fair trial, quote unquote, fair trial. So, and this is kind of railroading going on.
Move along with this. We can approach in a bit.
Thank
Look at even the doctor's like, oh, what's going on here?
you. What, if any, alternative diagnoses did you apply to Mr. O'Keefe?
I don't understand your question.
Yeah, she wants to stop the sidebar. She's trying to intimidate the defense to not making objections on the record that explain how this judge is so much in the tank for the prosecution.
What alternative scenarios did you look at, if any, for the cause or manner of death of Mr. O'Keefe?
I'll allow that question. What, if any?
At the time of the autopsy, I documented injuries and signs of hypothermia. I was provided with a set of circumstances. And at the end of the investigation, or at the end of, my timeline, I concluded on the cause, but I did not conclude, or I did not determine a manner. The manner would be the circumstances you are speaking about, whether I considered other causes or circumstances. That's not how it works. I don't come up with hypothetical scenarios on how those injuries occur. I try to state the injuries, describe the injuries, state the cause of death and why that person died. And then I use all kinds of other investigative information that is provided to me to determine if I have enough to make a determination on the manner.
Did anyone?
Okay, well, the point is, I've never seen a criminal defendant have headphones listen to sidebars. That also looks very odd and strange. You don't want your client looking too much like they're directing the lawyers to counteract and attack the government's case. You want the lawyers doing your work for you, not the defendant. So that's the only point I'm going to make about it anymore here today. Anyway.
Provide to you any alternatives as to the finding of the body of Mr. O'Keefe in the snow?
Personally, to me, no.
Did you ask for any alternatives to the nature and location of the injury or death of Mr. O'Keefe?
I asked for all the information that was available.
Understood, but my question is, did you ask for any alternatives to the information that was provided to you as regards the location of the injuries? Did anyone provide you any alternatives to where the injuries could have occurred?
No.
So
I'm going to let the answer stand. So the answer is no. So there's no evidence of that. So next question.
So
Yeah, there's no evidence of that there could be another theory. This is like a really improper thing for this judge to do, is to put weight on evidence like this and remind the jury, hey, there is no evidence. Yeah, because you are keeping it out. You and the prosecutor are trying to keep out the truth of alternate theories that are more based in truth than what you have seen here with the prosecution. So it's just, again, something that over and over again, every day, there's other points that collectively and overwhelmingly will result in reversible error if there's any conviction here.
You talked about the information you had at the time. What time is that?
The information at the time was a preliminary police report and verbal communications
And
regarding the circumstances of how Mr. O'Keefe's body was found.
And when I asked about the time, I'm on calendar time. Was this January, February, March, April of 2022?
The preliminary police report was on the day of the autopsy, and then information, I don't remember exactly how long, but in the weeks following, information was, coming in.
Are you guys still chatting about this? I really want to move on, but you're saying here she goes up because judge denied the earphones. Their attorneys aren't comfortable relaying info because it's such tight quarters in the courtroom. People always listen. You don't go back and tell your client what happened. Okay. I've never seen any attorneys do that. This is like really foreign. And you have Jackson, he's from out of state. He's from California. You have Alessi, he's from New York. You have the Yannetti, he's from the Boston area. So I'm just telling you, it's really strange to see a client going up to sidebar, coming to court with briefcases and having a laptop computer and acting like they're looking and acting like a lawyer. I'm just saying, I don't think that's a good image for a client to have, but it's not going to make a difference in this case. I'm just making that as a note that it's something that I would not do if I was the lead lawyer on that case.
Do you have the ability to amend a death certificate?
Yes, I do.
And you can amend a certificate if you obtain further information with regard to the circumstances surrounding the death. Is that correct?
That's correct.
In your previous answers, you were talking about the information you had at the time. And I'm concluding that the latest that would be is April of 2022. Is that correct?
Correct.
Have you obtained or been provided with further information? In other words, information after April of 2022 regarding the cause or manner of death?
What do you mean, have I been provided?
Excuse me.
Has someone physically provided me with a report on different circumstances?
Well, what I'm just talking about is any other information that you have received or considered in terms of the analysis with regard to the cause or manner of death.
Received in what way?
Here's what I'll do. I'll be a little more specific. What I want to do is to get at the head injury of the decedent, okay? Is it fair to say that the head injury, you called it a traumatic, state what you phrased that as, because I want to use your phraseology.
Blunt impact injuries of the head.
So blunt impact injuries of the head. Is it fair to say that that was a very severe injury?
It was a severe injury, correct?
And would Mr. O'Keefe had been rendered unconscious nearly instantaneously with death following shortly thereafter?
It's very possible, yes.
Is it more than possible? Is it probable that that's what would have occurred?
I can't tell you how quickly he would have been rendered unconscious, but at some point after that injury, yes, he would have been rendered unconscious.
Is it possible he could have been rendered unconscious immediately?
So she's answered it this way.
So they want to know if he could have gone unconscious immediately. And the prosecutor objects. All this stuff that helps defense he wants to keep out because that means that if he's knocked out, he's not able to still work on his phone. And that doesn't fit the prosecutor's narrative. So he doesn't even want the answer coming out. And this is such a farce,
Like you need
a sham trial.
another person for that. Let's move on from that, Mr. Lessie.
Okay, reversible error. Reversible error. Go ahead. Another reversible error. You still can't win this case. You guys are that bad.
You made your own determination of the cause of death, correct?
Block 90% of truth. You're still going to lose. You're still going to lose.
Correct?
Yes, that's my job.
Understood. And what I want to do is to pursue the basis of your determination. So you used the phrase brain impact injury,
Blunt impact.
a blunt impact injury. Have I got that correct?
Blunt impact injuries of head. Yes.
Of head, right. And that's your conclusion, correct?
Yes.
Based upon your conclusion, did you make any determination as to whether the decedent would be able to carry out any purposeful movement after that injury?
Define purposeful movement.
Sure. I'm talking about the ability to perhaps manipulate their hands.
I don't know.
Did you make any determination as to whether they would be able to engage in any cognitive functions, meaning processing things and making decisions?
I did not make that determination, no.
Did you observe any pattern to the injuries to the head of the decedent?
A pattern? I observed that there
Keep in mind, any of the injuries other than the arm and what we saw on the leg, so any facial photos from the autopsy, we're not able to see those here. The cameras didn't televise them. I don't know if that was their call or the judges, but we're not going to be able to see that in today's hearing. But the jurors did see that.
there
Or at
were
least have the opportunity.
injuries to the back of the head as well as other internal injuries to the base of the skull, as well as the brain.
Your Honor, if we could please publish, I'm just going to check to make sure they're in. If we could, Your Honor, publish 160 that is in evidence. But before we do, Mr. Wolf, I would like to approach Your Honor and let you know in case there's anything further
Okay.
that needs to be done. Thank you.
Did you show it to Mr. Brennan?
It's already been agreed to as in evidence. and it
Okay.
is in evidence.
Oh, it's in evidence?
Yeah, I just wanted to make sure if there was any statements that Your Honor wanted to make it now.
So why don't you come over here because, why don't you come over a second?
All right, let me try to jump this ahead. No, okay. I'm just moving these things here where I'm at in these StreamYard. Okay, here we are.
May I, Your Honor?
Yes.
Thank you. With Your Honor's permission, I would like to publish Exhibit 160.
Yes.
Thank you. Dr. Scordi-Bello, if you could please draw your attention to what is depicted on both screens. Pick whatever screen is most convenient for you. And what I want to do is to go over what is depicted there. And I'd like to start with just some basics. What is that white rectangle that is on the photograph?
This,
Yes.
that's a ruler
And what's the purpose of the ruler?
to show a scale. When I measure the injury, I use the ruler to document that.
And if you could please draw your further attention to what I will refer to, and you use your own term, but just to start it, the horizontal line that is appears to be a laceration. You know what I'm referring to?
This, yes, this is a laceration.
Right. So it's fair to say that that's a laceration.
Correct.
And just so we get all that's depicted on this, you referred to earlier up above that, the red area. And is that an abrasion?
Yes.
And do you also denote to the left almost like a J type item going vertically up? Yes, and going up. Do you see that?
Yeah, that I did not note that specifically. I just noted the whole injury as part of the abrasion.
That's my point. So you didn't make a separate note of what appears to be a J, and it might be easier to see it in the screen over there. It's your conclusion, but is it easier to see there?
Yeah, I can see it.
Yeah, and so you didn't make a separate note as to what that was in your report, correct?
No, I did not.
Do you consider that an abrasion or something else?
I believe that's still an abrasion.
Do you conclude that that J is different in any manner from the abrasion that you've noted above the laceration?
I believe it could be part of the whole abrasion, or it could be something different.
Fair enough. Would a fall backwards on a flat frozen ground produce a circular and not a linear abrasion as depicted here on the back of an injured person's head?
Can you repeat the question?
Sure. Assume a fall backwards on a flat frozen ground. Would such a fall and impact present that type of pattern, or would it present a circular pattern, perhaps with something like a starfish in the middle?
I'll allow that. Can you answer that?
I can say that a fall backwards could very well produce that injury.
My question is more specific, and that is a fall backwards where the person impacts the back of their head on flat frozen ground. Would you expect that type of a laceration from that type of a fall? Not just a general fall backwards, but specifically a fall backwards where the back of the head hits flat frozen ground. Would you expect that?
I could, yes.
And under what circumstances could a laceration like that and an abrasion, all of it together, what circumstances could cause that type from a fall backwards on flat frozen ground?
Well, the laceration is due to the blunt impact, and so is the abrasion. The abrasion is friction. So depending on...
Yeah, it looks like something metal, sharp metal, hit the back of his head. So smooth ground. I don't know why she's saying that. She also was not asked about the arm of John O'Keefe and she was blocked from talking about that, as I recall. But the thing is, you think she'd have knowledge of what a dog bite looks like, and so I don't think she even has experience dealing with that, because she's probably never saw what it looks like to have someone attacked by a dog. And because normally people survive, and we hear, every month or two you hear about another dog attack, somebody getting killed in the United States. But maybe she just haven't seen that. But anyway, I think that it gets better here for the defense.
The type of surface, you mentioned flat, frozen ground. It's quite possible to have an injury as the one depicted. There's nothing inconsistent with this injury, and a fall on someone's on the back of the head with a blunt surface.
Are you familiar with the phrase pattern recognition in medicine?
Yes,
And isn't pattern recognition something that requires training with regard to being able to recognize certain patterns and determining what could be causing that pattern?
yes,
And just merely recognizing whether there is a pattern takes certain specialty training, etc.
correct.
And isn't pattern recognition a principle that you apply in the medical examiner's office?
Yeah, we do.
And so example of pattern recognition could be a knife wound, correct?
Yes,
Could be a gunshot.
correct.
And there's certain patterns that you see on a decedent that can be consistent with those types of causes of injury, correct?
Correct.
Assuming a fall backwards onto frozen ground and there being on a lawn with grass, would you expect to see any grass at all in the injury site?
It's possible to have grass.
Is it possible to have are you familiar with the height and weight of the decedent generally? And if you need to look at your notes, please do so.
Yes. Mr. O'Keefe was approximately 6'1" and 216 pounds.
So assuming a fall backwards and an impact to head on a ground with grass, a person who's 6'1", there is going to be significant acceleration forces that occur as they're going backwards. Is that correct?
That's fair to say, yes.
And therefore, the more acceleration forces, usually there's a correlation with the force of the impact.
Correct.
And in terms of force of impact and assuming grass on the ground, would you believe it's more probable than not that one would then see some grass on the head?
Sustained is that form.
That form?
Given what you testified regarding the height of Mr. O'Keefe, and assuming what I just gave to you as a fall backwards and acceleration and forces, would you expect to see anything else on the back of his head?
You have to be more specific than that.
Right. I thank you. So would you expect to see, is it possible if that was the manner of the fall that there should be grass on the head? Is that possible?
Sustained.
Well, why would you sustain that, Judge? All right, we don't want the truth coming in. He's got grass stains supposedly on his pockets, back pocket, at least one of the pockets. If it's not blood, could be blood as well. We don't know for sure. But why couldn't he also have stains on his on his head as well.
Did you consider at all in your evaluation well, let me back up. Do you see any evidence of grass in this depiction?
No, I do not.
Did you recall ever seeing any evidence of grass when you were performing the autopsy?
I did not see evidence of grass.
Did you consider
There's nothing about the prosecution's theory that makes any sense at all. It's just complete garbage.
at all in performing your autopsy whether or not grass should be present given what was reported to you by law enforcement?
Sustain.
Did you make
All right,
any
reverse Boyer.
considerations at all regarding grass in regard to your
There's probably like, I don't know, over 50, 60 points of reversible error in this trial so far. You get multiple each day.
autopsy report?
I did not see any grass. No, I did not make any determinations.
And was grass at all even a consideration in your analysis?
I had very limited information as to the exact nature of the surface at the time of autopsy.
So the answer is no to that
No.
question. Thank you. Did you have any information regarding the circumstances that you said you look at in trying to determine manner of death as to whether there were any stones or rocks around the scene?
That I did not have any information.
So meaning you didn't have any information, you saw no information that there were any stones or rocks by the scene, is that correct?
Sustained in that form.
What, if any, consideration did you make in your assessment of cause and manner of death with regard to stones or rocks?
I did not make any.
With regard to any other potential causes other than ground, did you consider any other possibilities that could cause the type of injuries that are depicted on the screen?
There's a number of possibilities that could cause the injury.
My question is, did you consider, not whether there are, but whether you considered them at the time you were performing the autopsy?
I'm always considering at the time of autopsy what could have caused a certain injury.
Did you put in your notes or your autopsy report any of those considerations? Are they documented?
No,
Now, in terms of differential diagnosis that we talked about, did you determine whether there were any other possible explanations for the injuries to the decedent other than what law enforcement presented to you?
I'll allow that.
Finally.
internally, I consider all kinds of other explanations. I have to look at the findings and the possible ways that those injuries could have been sustained and decide whether I have enough information and whether I am satisfied with the information that I have in order to conclude or determine a manner.
Did you make any notes at all about the considerations you were just speaking about, other considerations? Any notes whatsoever in any document in your autopsy report?
Not in my autopsy report, no.
Did you make any other notes of those considerations in any document that you created for this case at all?
No, these are considerations that I've had and discussions I've had with colleagues in terms of evaluating these injuries and.
And I don't want you to go into what other people said, but I want you to finish your answer.
Right, no, I did not make physical notes of my considerations.
Yeah, this is being a bit delayed here and getting to some good points. I agree with that, Stevie Howe. But one of the things I've not seen yet at all from defense questioning is how much blood John O'Keefe lost and where is that blood? So they could have used this witness to bring that out as well.
Your Honor, I'm going into a different category, so I just wanted to alert Your Honor to it.
All right. And it will take more than 10, 15 minutes?
Oh, yes.
Okay. All right, jurors. Oh, we'll take the lunch and recess. So we'll see you in about 45 minutes.
Rise to the jury.
All right, let me jump ahead here then.
And you indicated in that grand jury proceeding, generally the diagnosing hypothermia is based on contextual clues. Is that correct?
On autopsy findings and investigative information, yes.
Right. And the last part, investigative, and that's that legal part, sort of the law enforcement contribution. Is that correct that you're referring to?
Correct.
You diagnosed Mr. O'Keefe with hypothermia based upon certain medical data that you believe you observed in the gastric area and the pancreatic area. Is that correct?
Correct.
And just for, I think most people will get this, to just be clear, gastric is sort of synonymous with the stomach.
Stomach.
And then we know the pancreas is a separate organ. And in your autopsy,
Hey, red green falling backwards. Ooh, hit the wrong spot there.
welcome back.
Thank you.
Hold on a second.
Your hypothermia.
Falling backwards can also cause significant brain injury. It depends what you hit your head on, and the injury to John O'Keefe's back of his skull, common sense tells you it was something sharp that he landed on. There's nothing sharp in the yard. This solid grassy ground that's frozen or semi-frozen state is not going to cause a cut in the back of your head that fractures your skull that looks like somebody with a hatchet hit in the back of the head with. So I think it's pretty common sense. Some of the prosecution is just trying to
Analysis,
Wait.
is that correct?
The histopathology was done to further confirm my finding or my determination of hypothermia.
So do I have it correct? And let's start with the pancreas. That you noted the pancreas was congested and diffusely hemorrhagic. Do I have that correct? And you feel free to look at your report, please.
I will.
Yeah.
And I
That's the other thing as well. If he was hit backwards and he landed on his back, why is all that blood on his front of his shirt and jacket area? Think about that pinkish type of shirt he had, all the blood on there, and also that hoodie jacket he wore. There's way too much blood there for someone to be hit and laying on their back with a fractured skull with an open wound that's bleeding.
specifically, if it helps, I'm
Yes.
looking at
Page 4.
the report of autopsy. It's not numbered pages, but it would be 4. And you see liver, gallbladder, and pancreas is 1. And then you go down a couple more and you see digestive system. That's what I'm focusing on.
Okay.
And then, and the next,
Yeah, even if it's objected to, at least get that out there. There's something. How could he been having those injuries in a fight? Do a fight scenario.
next page is the histopathology.
Yes.
All right. Are we sort of oriented in the same location?
Yes.
All right. So
Yeah.
let's start with the pancreas. So if you look at the histopathology page, it says endocrine and exocrine pancreatic tissue with vascular congestion in patchy parenchymal, that's parenchymal hemorrhage, autolytic changes. Did I read that correctly?
Yes.
And I want to go at these one at a time. So now I'm going to jump back to the previous page where you discussed the heading liver, gallbladder, and pancreas. Do you see that?
Yes.
And you see the last sentence says the pancreas is congested and diffusely hemorrhagic. You see that?
Yes.
So now what I'd like to do, and is that what you're rooting in, if you will, the analysis of hypothermia?
The determination of hypothermia was made, yes, based on these findings and the circumstances that was provided. Yes.
Right, and thank you. I'm going to get to the circumstances, but it's sort of the medical legal construct that we were talking about. I want to just start first with the medical, if that's okay with you.
Yes.
So then let's now move to the organ of the stomach, a synonym gastric in terms of your report. So let's go to, please, back to the histopathology section. And under that, under pancreas is stomach. And there's a bulleted one sentence that says gastric tissue with vascular congestion and focal mucosal hemorrhage. Did I read that correctly?
Yes.
And then let's go back, as we did with the pancreas, for the stomach, go back to the previous page in your report under the heading digestive system. And the second sentence states the gastric mucosa shows focal areas of linear hemorrhages. Did I read that correctly?
Yes.
So we've got hemorrhage discussion with the pancreas. We've got hemorrhage discussion with the stomach and the gastric area. Your diagnosis of hypothermia was not based just on gastric and pancreatic hemorrhaging alone, though, was it?
No.
And you did fairly refer to other circumstances just moments ago in your answer, correct?
Correct.
And we're going to get to that. So that means that your diagnosis of
That's a good way to say it, Tanya Bluebell. Without a proper investigation, then instead the prosecution shaping the evidence, in some cases altering the evidence in order to promote their theory, or else getting hired gun experts to try to align with their theory.
hypothermia was also informed by the information we discussed earlier that was provided to you by former Trooper Proctor in his investigation. Is that correct?
Correct.
And one aspect of that information is that he was found, Mr. O'Keefe was found in the snow, correct?
Yes.
So let's go to the death notification report. Am I generally correct that you were, I'm sorry,
Rephrase it.
I will. Thank you, Your Honor. Do you recall the death notification report in this matter?
I do recall, the very initial first information that comes in. That's the death notification given to our intake staff.
Do you recall the contents of that death notification report?
Would you like me to summarize? I don't recall I don't have it in front of me, but I can tell you what the gist of it was.
Would it be helpful to you if I showed you a document that
Sure.
might refresh your recollection on what that, a document that may refresh
She
your recollection?
said sure. I
Thanks.
don't think you heard her.
I did. Thank you, Your Honor.
I hope so. Having such a young jury, I've not experienced that before from what I'm hearing the younger ages of the jury members. And so would they be more critical of prosecutors and law enforcement officers and judges' behavior that's out of line, like this judge? I just don't have experience with that. So I wish I could be there to read this jury. I think I could hopefully read them like I can a normal jury, but since we have a very unique jury, they still got to be seeing this. If they have any common sense.
Yeah, Coach.
Yep, just show Mr. Brennan.
Yeah, that's true, Teresa. Sensitive disrespect and bullying. They can recognize bullying easier.
Yes.
Dr. Scordi-Bello, what I'd like to do, you can read anything you want, but I'm just going to reference to the section that says circumstances of death.
Yes.
What I'd like you to do is read it to yourself, not out loud, and then when you just that section up to here. And once you're done, if you could kindly look up and let me know.
Okay.
Yeah, attention spans are real critical. But if they've already formed the determination that government doesn't have a case,
Dr. Scordi-Bello, did that refresh your recollection with regard to the circumstances of death section of the death notification report?
Yes.
And you,
hey, that's a good point here. Kim, have you noticed the way this judge constantly cuts off defense attorneys, even Alessi? He'll start to say something and she'll just cut him off mid-sentence. Even if where she's going to grant him something he's requesting, she just has no respect enough to wait till they finish asking the question. It's just so inappropriate, and it's ongoing, and it's really embarrassing to see.
you could please state now what your refreshed recollection is on that topic.
Yes. The initial intake death notification was made by a physician at the hospital. And it stated that we were dealing with a adult male that was found in a snowbank. There was note of having been at a party. There was some information as to the decedent was walking to a house. There was reference to some sort of altercation or dispute with
Sustain. Jurors, disregard that. Move on with this, Mr. Leslie.
Yeah, move on.
With this, but just move on.
Yeah, yes.
Let's move on. Come on.
In terms of the differential diagnosis concept that we were talking about before,
I think that if we got this younger jury, I think they'll see this judge is being a bully to the defense.
based upon your refreshed recollection of circumstances of death as discussed in the death notification report, based upon that, did you consider whether Mr. O'Keefe could have been injured and died somewhere other than the front lawn of 34 Fairview?
Yes.
I'm going to allow that.
initially, no.
Let's go to significance, if any, of hemorrhaging of the two organs we were talking about, the pancreas and the stomach. Is it correct that the hemorrhaging of a pancreas can be caused by many different things?
Yes, it is.
And to be clear, you found evidence of hemorrhaging of the pancreas of Mr. O'Keefe in Mr. O'Keefe in the autopsy, correct?
Correct.
Interesting.
And is it correct before the grand jury, you yourself were evaluating whether the injuries had been sustained in a different environment? Well, let me ask it this way. Do you recall what your testimony was in the grand jury about hemorrhaging of the pancreas and possibilities of injuries being sustained in different environments? Do you recall any testimony on that subject?
All right, I'll see you at 10.
Yeah, what happened to the cutting back on sidebars? Wasting all this time because you don't have fair rulings. Brennan's just encouraged to object as much as he wants.
May I, Your Honor?
Yes.
Thank you. At the grand jury, did you testify as follows? If the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. You recall that?
Yes.
Hemorrhaging of the pancreas can also be caused by blunt force trauma, correct?
Correct.
Hemorrhaging of the pancreas can be caused by CPR, correct? Cardiopulmonary resuscitation.
It's possible.
Nothing this bad, not even close for a judge. Open hostility and prejudicial hatred. It's really hatred, the way I see it.
Do you know what a Lucas machine is?
Yes.
And a Lucas machine is an automated CPR machine, correct?
Correct.
And it's a rather large device, correct? It gets strapped down to the chest of someone. So instead of someone having to exercise, etc., you put on a Lucas machine that goes over the chest and it automatically does the compressions, right?
Correct.
Lucas machines can cause hemorrhaging, correct?
Yes.
And in fact, wasn't a Lucas machine applied to Mr. O'Keefe?
I believe so.
And wasn't the Lucas machine applied from when the first responders came to the scene and he was in the ambulance continually and through when he was in the hospital?
I believe so. Yeah.
So
Yeah.
when a Lucas machine is used in resuscitation efforts, you'd actually expect to see some hemorrhaging, wouldn't you?
Where?
In the stomach, in the pancreas, would you expect to see it there?
Not in the mucosa of the stomach and not as extensive in the pancreas.
Let's talk about and pick the pancreas first. So you would agree that from the use of a Lucas machine, you would expect some degree of hemorrhaging in the pancreas, correct?
Not always.
But it's certainly possible that a Lucas machine causes hemorrhaging of the pancreas, correct?
It's possible.
And now let's move to, and there was evidence.
So keep in mind, Alessi here is trying to show that this hypothermia is maybe not so concrete as she was making it out in original autopsy, because there's other explanations for why those signs, what she interpreted as hypothermia, could be something else, i.e. this machine.
Evidence of hemorrhaging in the pancreas of Mr. O'Keefe, correct?
Correct.
Now let's move to the stomach. Isn't it possible that a Lucas machine
So she just admitted a Lucas machine could be the reason that the pancreas for John O'Keefe looked the way it did.
could cause hemorrhaging in the stomach?
Personally, I have not seen it in that context.
Or do you rule that out?
I can't rule it out. I can only tell you my experience.
So your personal experience is you don't believe you've seen that, but you can't rule out that a Lucas machine causes hemorrhaging to the stomach. Is that correct?
I don't believe a Lucas machine causes hemorrhage to the mucosa of the stomach.
Right. I'm not yet at the mucosa of the stomach, which is a subset of the stomach, right? You're talking about the gastric rugae.
Talking about the inner lining of
The
the
inner
stomach.
lining, and another name for the inner lining of the stomach is the gastric rugae, R-U-G-A-E, correct?
Yes.
So I'm just talking about the stomach in general, not a subset of the stomach. Is it possible that a Lucas machine could cause hemorrhaging in the stomach?
Not in the stomach, around the stomach and the soft tissues of the torso.
Okay. So you've said that you're aware that Mr. O'Keefe was hooked up to a Lucas machine, correct?
Yes.
And are you aware of the length of time that Mr. O'Keefe was hooked up to a Lucas machine?
No, I am not.
Do you know how many compressions per minute a Lucas machine causes?
I would have to say close to 60.
Would 100 compressions per minute be a reasonable amount of compressions for a Lucas machine to cause?
Sure.
So assume 37 minutes of a person hooked up to a Lucas machine and assume 100 compressions per minute. That would result in 3,700 compressions from a Lucas machine, correct?
That's a lot.
Correct.
Could 3,700 compressions from a Lucas machine explain hemorrhaging in the pancreas?
You could.
And that explanation could be why there's hemorrhaging in the pancreas as opposed to hypothermia causing hemorrhaging in the pancreas, correct?
Possible.
Did you
you
consider
go.
that at all in your autopsy report, the effect of the Lucas machine? Is it written anywhere in your autopsy report?
I do consider changes due to cardiopulmonary resuscitation. The rib fractures that were observed were attributed to CPR. Usually we will see some amount of hemorrhage in the soft tissues, but in this context, with the gastric findings, the pancreatic findings, and the information that he was found in the snow with a body temperature of 80 degrees, my opinion was that those hemorrhages, along with the gastric hemorrhages and his body temperature, were consistent with hypothermia.
Yeah, but how long was he outside in the cold? That's what I think would be interesting to delve into here.
My question was, does your report state anywhere the words Lucas machine?
No,
And you agree that a Lucas machine could cause hemorrhaging to the pancreas?
it can cause hemorrhage in a lot.
Well, I think what he's trying to establish is that, okay, she's already saying it's not consistent with a vehicle strike. So what he's also trying to show now is the determination of hypothermia that is in doubt or could be ruled out through other reasons like this Lucas machine. So that basically makes it a narrower window that John would have been out there on the lawn if it wasn't hypothermia, because you're not going to be out there over 5 hours and not have frostbite and hyperthermia. So it's already been established through her that John had no frostbite that was observed. So no hypothermia either. That really looks like it's more recently that he was put out there on the lawn.
A lot of tissues,
But including the pancreas?
including the pancreas.
If you see hemorrhaging of the pancreas and you believe that hemorrhaging is a contributor to hypothermic deaths, wouldn't you also expect to see Wisniewski ulcers?
I did note gastric hemorrhages.
So the court reporter needs to have a spelling of that. Doctor, can you give us the spelling of that?
Would you like to give it?
If you'd like me to, I prepared to give
ahead.
it. Thank you. Wisniewski. So can you just tell the jurors what Wisniewski spots or Wisniewski ulcers are?
Wisniewski spots are small hemorrhages, small areas of bleeding in the mucosa of the stomach that are thought to be associated with hypothermia, among other things. They are believed to be either a reaction to stress due to the hypothermia or some form of what we call reperfusion injury.
Is it correct that if someone is believed to die, at least in part, from hypothermia, that in 90% of the cases of death from hypothermia, you would find Wisniewski's ulcers?
I do not know the exact number.
Is it that you're not recalling what the percentage is for the percent of cases for death of hypothermia that you would expect to find Wisniewski's ulcers?
I don't.
Do you recall?
Hold on.
Okay.
Move on. The objection sustained. So
Okay.
you're asking it. Yes, go
Okay.
ahead.
There were no Wisniewski's ulcers present in Mr. O'Keefe. Is that correct?
I believe there were.
Can you point anywhere in your autopsy report where the word Wisniewski appears?
I did not call them Wisniewski spots. I called them gastric hemorrhages.
Right. So you didn't use the term Wisniewski and you didn't use the term ulcer, correct? In your report at all?
No, I used gastric hemorrhages under the title of hypothermia.
Do you believe that all hemorrhages in the pancreas are Wisniewski ulcers?
You mean the stomach?
I'm going to start with the pancreas.
Wisniewski ulcers are the term is used to describe the gastric hemorrhages.
Right. So I wanted to clarify that. So now I want to move to the stomach.
Okay.
Do you believe all hemorrhages in the stomach are Wisniewski ulcers?
Not all of them.
Therefore, there can be Wisniewski ulcers and not be hemorrhaging, correct? Just by logic?
And not be hemorrhaging?
Correct. You can have a Wisniewski ulcer but not have hemorrhaging.
You could, but ulceration would manifest in what we call hemorrhage, the actual appearance of it.
What I'd like to do now is, Mr. Wolf, what has been in evidence, what I'd like to do is to, with your Honor's permission, publish some depictions of first the gastric mucosa, and then start with that, Your Honor, publish that.
All right. So this is the one that we have not introduced into evidence openly, but it's sidebar, right?
What I'd like to do is I'll start out with the one that is in evidence, which is the gastric mucosa.
Okay.
Start with that.
What number?
Your Honor, just to
Okay, so that was the one I was referring to that we did at sidebar, not in open court. Okay.
Yes.
It's right.
Pardon me?
It's N and right.
And I'd like to move N into evidence at this time.
All I'll say about this, jurors, is that this may be considered graphic. You satisfied with that, Mr. Alessi?
I'm satisfied with that, Your Honor.
Okay, Mr. Brennan, you satisfied with that?
Yes, Your Honor.
Okay.
164.
May I, Your Honor?
Yes.
Dr. Scordi-Bello, I'm handing you Exhibit 164 in evidence, and I'm going to also, with the court's permission, have it published on the screen. So whatever one is best for you to look at the screen, please feel free to look at either one. Mr. Wolk, if you could publish 164. Dr. Scordi-Bello, do you recognize 164 as well, you describe what 164 is.
This is a picture of the stomach of Mr. O'Keefe after it was removed and opened and the contents were removed. And what you're looking at, this pink red surface, is the mucosa. That's the
This is a photo of that I've not seen anywhere on the internet, so, and we're not going to see it here.
lining of the stomach. And you had used the word rouillé before. These are the folds. The stomach has a lot of folds. And what you can see here are small areas that are redder than everything else. That's hemorrhage, that's blood. And these are the gastric hemorrhages that I described.
Right, so those are what you just showed. There's darker areas, there's just a few of them. That is what you refer to as hemorrhages, correct?
Wisniewski's was correct.
Well, you didn't use Wisniewski's in your report, correct? You referred to
Correct.
them as hemorrhages.
Correct.
Okay, so what I'd like to do now is to, if I may approach, Your Honor?
Yes.
To the chalk.
Exhibit MM.
And with Your Honor's permission, may I show Dr. Scordi-Bello the chalk that's marked for identification? Is that it?
Yes, and let's see what she answers before we use it for more questions, okay?
Yes. May I hand it to you?
Yes.
Dr. Scordi-Bello, could you please take what's identified as Exhibit M and see if you can identify what that depicts?
Yes, this is a picture of a stomach. Again, the mucosa with hemorrhage.
Just hold for these, not your fault.
Your Honor, can we take a break?
Yes, yes.
Please rise to the jury.
All right, break. Let's jump ahead.
Yes.
I don't know that why he wanted to show the photo of the stomach, but if it's pretty gruesome, but I guess he's trying to make a point that there's other reasons besides hypothermia. Here we go.
Exhibit fairly
Yes.
interview.
Seated court is in session.
All right, Mr. Alessi, you can continue where you left off.
Thank you, Your Honor. May I agree approach to this?
Yes.
Dr. Scordi-Bello, you have in front of you, which has been marked for identification as MM, and you were discussing that. Do you recognize that document? Since it's sort of start over to reorient. You recognize that?
I recognize what it is, yes.
And what is it?
It is a picture of a stomach, of the mucosa of a stomach with multiple hemorrhages.
And does that exhibit fairly and accurately depict a stomach with what you have referred to as multiple ulcers?
Yes.
Your Honor, I offer that into evidence.
I definitely agree.
I'll, you know what, if I can use it as a public, a chalk publication. Yeah, that's what I'll do, Your Honor. Thank you.
So you can have it displayed.
Thank you. And again, I'll leave this hard copy with the court reporter, and we'll use the.
Oh, so it's not in evidence?
It is not.
It's marked for identification?
Yes, marked for identification, and we are with it. Mr. Wolf? Dr. Scordi-Bello, is that the depiction that you were just describing at your witness stand?
Yes.
And could you please, with the laser pointer, state what you see in this depiction?
So this is a stomach. This is the mucosa, the folds of the stomach. They're not very folded in this particular picture, but you can see these distinct areas that are that have a darker coloration. That's blood. These are hemorrhages.
And to be clear, this is not the stomach of Mr. O'Keefe. This is a medical reference depiction to sort of generic or some other depiction other than Mr. O'Keefe's stomach, correct?
Correct.
If we could, with Your Honor's permission, Mr. Wolk, put side by side this chalk with what is in evidence as the actual gastric mucosa of Mr. O'Keefe.
All right, I'm going to
The objection sustained.
Could we, with Your Honor's permission, publish simply Mr. O'Keefe's
Yes.
gastric mucosa?
Yes.
Isn't it correct, Dr. Scordi-Bello, that there are much less dark spots in this depiction of the gastric mucosa than there were in the chalk that we just displayed? In other words, that green depiction of what I'll just refer to as a generic stomach. Is that correct?
That is correct.
So you can take that down, Mr. Wolf.
I'm going to jump ahead on this.
Let me read that injury to the right eyelid, that laceration, could not be caused by someone falling backwards and hitting their head, correct?
Correct.
Bear with me one moment, Your Honor. May I approach, Your Honor?
Yes. Show Mr. Brennan.
Your Honor, I erroneously assumed that that picture was in evidence, and I would like to now properly lay the foundation of it. Dr. Scordi-Bello, you see what's in front of you. Can we mark this?
So, Mr. Brennan, are you objecting to that coming into evidence? Okay, so let's just put it in evidence.
165.
Thank you.
So, Dr. Scordi-Bello, that laceration to the right eyelid could not be caused by a fall backwards where someone hits the back of the head, correct?
Correct.
So that
This is a good
injury,
point here.
you've called, what do you label that category? Traumatic, did you use that phraseology?
Blunt
Blunt
impact.
impact. So that's a blunt, in your opinion, that's a blunt impact injury, correct?
Correct.
So is it correct that that injury had to occur?
Think about if John O'Keefe got hit by the vehicle, where did he get hit at? And then how did he land on the back of his head? Where's the body strike impacts? Where's the blunt force trauma on his body that would have broken bones? And it wouldn't have done that kind of damage to the taillight. And there probably would have been more damage to the bumper.
In some manner other than falling backwards and hitting one's head?
I should say more damage. There would have been some damage to the bumper or part of the fender housing.
Yes.
And is that injury consistent or inconsistent with a punch?
I'll allow it.
Can you believe that? Hank Brennan's trying to block this question from coming out. Could that eye injury be consistent with a punch? This is outrageous. Again, look how many times he's trying to cover the truth from the jury. If the jury members can't see it for what this is, that he's blocking truth from coming out.
Could be consistent.
If we could, Mr. Woke, have the laceration to the nose?
Yeah, okay, I skipped over that.
I'm sorry, hold off on a moment.
Drinking medication, thank you.
Your Honor, Mr. Brennan has agreed to stipulate this going.
Okay, so like we can mark it.
166.
Okay, thank you.
May I, Your Honor?
Yes.
Thank you. Dr. Scordi-Bello, I have put before you what is in evidence is 166, and Your Honor may, Mr. Wolf, publish.
Yes.
Thank you. Dr. Scordi-Bello, does that exhibit fairly and accurately depict the laceration to the nose of Mr. O'Keefe?
Yeah, it's an abrasion. I described it as an abrasion, as a scrape.
So you would classify that as a scrape?
Yes.
That scrape could not be caused by someone falling backwards and hitting the back of their head, could it?
Not by a single event, no.
You can take that down, Mr. Wolf.
Yeah, Leslie's really good. I can see him doing the closing.
On your direct testimony, you talked about
You know, the one thing about, I would say, the difference between him and Jackson can talk faster to make points, but sometimes I think he can talk so fast the jurors may not track it all. And anyway, I could see a Leslie doing it as instead of Jackson on the closing, and they don't have a lot of time. Last time, what was it, an hour? So they need to ask for at least 90 minutes.
injuries to the right arm of Mr. O'Keefe. Do you recall that?
Yes, I do.
And is it correct that you, in your autopsy report, did not determine the cause of those wounds to Mr. O'Keefe's right arm?
That's correct.
With your Honor's permission, I would like to Mr. Brennan. Please have them
Yes.
mark as next evidence.
And 168.
Thank you.
I'm going to do the same thing if I may, Dr. Scordi-Bello. I'm going to leave these with you, but I'm also going to read the court's permission, have them published.
Okay.
To whatever one best allow you to answer the question. Your Honor, may I have Mr. Wolf publish those too? Thank you. With regard to what is on the screen, am I correct that you noted these injuries these wounds to Mr. O'Keefe in your autopsy report?
Yes,
And am I correct
at-
that you noted that there was a pattern to those wounds?
correct.
And although you noted there was a pattern to the wounds, you were not able to determine the cause of those patterned wounds. Is that correct?
That's correct.
What's weird is she didn't have an opinion as to how these would have occurred. She's definitely saying it's not from a motor vehicle accident, but she doesn't have any insight into what would have caused this.
Are those injuries consistent with a dog bite?
Based on our answer to the last question, ask something else.
I'm sorry.
Can you believe that? That won't come in and where this was caused by dog bite.
Injuries consistent with a dog bite?
Absolutely disgraceful. You can't say something other than what this was that this is a car accident. A car struck this arm and caused this kind of damage. It's absolutely ludicrous, laughable, insane to have that theory have any amount of traction. And yet that's how absolutely radical this prosecution team is and this Morrissey-led office is, that they think they're going to get a conviction with this kind of evidence. Absolute trash. Absolute trash.
Based on our answer to the last question, ask something else.
I'm sorry, couldn't hear.
Ask another question, sustain.
Ask another question, sustain. No, you're having a sidebar. We're not going to challenge a judge again. This judge is out of control.
Can you identify any cause of those injuries that would be consistent with what is depicted on the screen? Okay.
So can you answer that, Doctor?
I cannot.
So she hasn't any. Okay, so prosecutor objected again. Now the judge finally allows that question. Just it's so open ended. You can't mention a dog, and she says no. So you can't. In other words, what she's telling the attorney here is like, you can't go down this line of questioning, saying, "Well, why wouldn't it be consistent with a dog bite? A dog bite have you done comparisons, and have you seen that they have linear marks like this on the arm that are parallel that indicate maybe the claws or the teeth were making the lacerations." Yeah, those kind of questions here. Don't the upper gashes appear from claws? Are you experienced looking at dog bites? That's the kind of questions you should be able to ask her on cross-examination. But the judge is clearly wanting to shut this line of questioning down. So that's why I'd keep pressing away, asking for sidebars. I wouldn't just rely on Dr. Russell.
You can take that down, Mr. Wolf. Thank you. Do you recall discussing at all on your direct examination? Well, let me ask it this way. Did you evaluate at all in your autopsy a gray hoodie sweatshirt of Mr. O'Keefe?
No, I did not.
So were you aware that there was clothing associated with Mr. O'Keefe when he?
But they never tested any of the taillight pieces. That's what a joke this prosecution is.
Came as part of the autopsy?
He did not have any clothing that came to us. The clothing was removed at the hospital and was packaged and I believe submitted as evidence.
So the clothing of Mr. O'Keefe,
Yeah.
t-shirt or hoodie, didn't make its way to?
No,
Yeah, that's basically, you could say that also the judge doesn't want another theory coming out, so she doesn't want any mention of a dog. So you can just talk in generalities, but you can't go down and flesh out this issue about a dog. So the prosecution doesn't want this truth coming out, so why isn't the defense raising this issue on a sidebar?
You were unable to reach a determination as to the manner of death of Mr. O'Keefe, correct?
that is correct.
So you have doubts about the manner of death of Mr. O'Keefe, and you consider those doubts reasonable?
Sustained. Sustained.
You were not able to reach a determination as to the manner of death of Mr. O'Keefe, correct?
Correct.
And manner of death, as you've testified, includes the circumstances surrounding death in addition to the medical analysis that you performed.
I'm sustaining it, asked and answered.
Oh, saying as asked and answered. Okay, well, let's go back and listen to that one again.
In to the medical analysis that you performed. Inclusion as to the manner of death of Mr. O'Keefe, correct?
Correct.
And manner of death, as you've testified, includes the circumstances surrounding death in addition to the medical analysis that you performed.
All right, so right there, she's saying you cannot determine the cause of death, how John O'Keefe died. You can't say it was from a car. If you can't say it's from a car strike, the government's case is just crumbled right before him here. So this is like a huge moment. This is a massive loss for Hank Brennan. He can try to recover with another expert all he wants. This is the one that examined John O'Keefe. This doctor will have the credibility that the jury needs to think she's not a hired gun. She's just doing a routine job. I would think she knows more about the dog bites, but there's other experts for that. She's never seen anybody that's been killed by a dog bite, so that's probably why she doesn't have that kind of experience.
I'm sustaining it, asked and answered.
Thank you for answering my questions, Dr. Scordi-Bello.
You're welcome.
All right, thank you, Mr. Leslie, Mr. Brennan.
Yeah, and asked, do you notice that these holes, puncture holes on the hoodie that John O'Keefe was wearing are consistent with these tears in the flesh of his arms?
Doctor, how many autopsies have you performed in your professional career?
At this point, more than 1,200.
When the person is brought to you, are they usually clothed?
It depends on the circumstances. If a person comes directly from their residence, they may or may not be clothed. If the person comes from a hospital where they went first, for treatment. Many times the person is unclothed. They may be wearing a hospital gown, but in most cases that clothing has already been removed.
If that clothing has already been processed, is it common that it would be brought to you for inspection?
Objection, Your Honor.
Sustained as to.
Is clothing that is not accompanying the person's body commonly brought to you for observation?
Objection, Your Honor.
So let's move on.
Finally,
Or
she tells
actually,
You were asked
Pink,
questions
move on.
about your opinions relative to spots in the organs of Mr. O'Keefe. And you were asked about part of your statement in the grand jury. When you provide statements, is it important to have the statement in context to understand it?
Yes,
Is it important to have a complete statement rather than just part of a statement?
yes,
And when you were asked the
Listen to
question
that. Okay,
that
that's
counsel
what I've been
asked
doing the
you,
whole trial.
rather than
Given
just part of
partial
a statement, you
snippets of
provide statements,
Karen's
is it
statement.
important to have the statement in context to understand it?
yes,
Is it part of your
Listen,
spots in the organs of Mr. O'Keefe? And you were asked about part of your statement in the grand jury. When you provide statements, is it important to have the statement in context to understand it?
yes,
Is it important to have a complete statement rather than just part of a statement?
yes,
yeah, and that's what you've been doing this whole jury on and on every day, putting little short clips of Karen Reed talking to media. You don't show the full context. And funny, you know you're doing that and how misleading it can be because now you're trying to bring that out because the defense didn't go into more detail. Hopefully the jury picks up on that.
And when you were asked the question that counsel asked you, do you remember that grand jury testimony you gave?
I remember it was a long time ago,
Okay.
but I do remember most of it.
Do you remember when he read part of your answer? It was in response to a grand juror's question.
Yes,
And he read part to you, right? I understand your question. And my answer is that I don't know, but given the environment, so if the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. Do you remember that?
Objection, Your Honor.
the doctor can answer that.
Do you remember Attorney Alisi read you that part of your statement?
yes,
Do you remember that you had more to that statement that was left off when he confronted you with it?
I'm sure there's more to this.
To complete your statement, you said, but in the whole context, I believe that those are signs of hypothermia and not caused. Do you remember that completion to your statement?
Objection, Your Honor.
Sustained, you can show her the statement.
Okay. I can approach.
You've already lost. There's no
Ask you to take a look at
redirector. It's going to save
part of your
you.
grand jury testimony. Do you remember Attorney Alisi reading part of your answer back?
Objection, Your Honor.
So I'll strike that. Have the witness look at it and go through it.
You asked about your entire answer or just part of it?
Objection, Your Honor.
Sustained.
You can read
Finally.
the rest of the answer that you weren't given when it was read to you.
Objection, Your Honor.
So this is phrased as refreshing recollection, so follow it appropriately.
Do you now remember there was more to your answer?
So she sustains, but then tells them how to fix it.
Yes,
Could you share with us the rest of your answer?
Without reading
Objection,
it.
Your Honor.
Without reading it. Turn it over, turn the paper over, please.
I can take it, Your Honor.
Ask the appropriate questions to her.
Do you remember the part that was left out?
Objection, Your Honor.
Sustained.
Does it refresh your memory to the rest of your statement to the grand jury?
I've never seen the judge do this many sustains for the defense. I mean, this is probably as many as they've gotten in a whole week. The most they've gotten in a whole week. They got a series of them right here.
I'm sorry, what was your question?
After looking at this, does it refresh your memory to the rest of your statement you made to the grand jury?
Yes.
The rest of your statement. See how nasty Tony's gotten? This is your own witness.
And could you share the rest of your statement with the jury, please?
The rest of the statement was that I have to take those findings in the context which was presented to me. So in the case of this particular case, those hemorrhages, the context of a body found in the snow, I believe they were due to hypothermia.
Is your answer more complete in context?
Objection, Your Honor.
Sustained.
You were shown a photograph of two individuals that were in the room at the time of autopsy. Do you remember that photograph?
Yes, I do.
And you were asked about certain names.
Correct.
You said that there would be a log identifying names.
It would be a log. Yes.
A log. Do you remember exactly who logged in to that autopsy?
No, I don't remember their
I'm
name.
going to jump ahead. Stand by here. I'm going to jump ahead to
Mr.
the
Burgess states that he
Alessi's
is making
motion regarding
an
sure.
amendment, and he is now stating that the
So just keep that in mind, folks. How often are you going to see a murder case where the state's own medical examiner can't even say it was a homicide? Can't even say it's a homicide. It's undetermined what caused his injuries. I mean, it doesn't get much worse than that for the prosecutor. So that's why this is a huge day. It's a huge momentum builder for the defense. And everything this prosecutor's doing is all tricks and ambush. And that's the only way he can win, is to try to do sneaky stuff and bamboozle and hope the jury is dumb enough not to figure him out.
You may be seated.
All right, so Mr. Alessi, I'll hear you. I'll hear you, Mr. Alessi.
Thank you, Your Honor. The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welcher, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes. That
Okay.
My understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So the Commonwealth has established in reports right up until not established, they had stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher, a trigger called 1162.2 that they have associated in the report of Dr. Welcher with a specific time. And that specific time that they have associated with.
If you guys want me to go back a certain time, then tell me where you want me to go back to, because this is a half hour right here, and it's going to be midnight. So if it's worthwhile, I'll go back, but I'm not going to be searching for that part, please. This is on the Boston 25 News today. You can see it's 7 hours, 44 minutes.
That trigger is 12/31/38 to 12/31/43. And we have been assuming that information, and this is from best memory, but I believe it's slide 137 or so, where the statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. No, I'm just going to get it. So, although it was dated May 8th, we received it actually on May 11th.
So they
And
received
in
notice
that
on May
report,
11th. Today's the 15th.
Mr. Burgess states that he is making a
So Shannon Burgess is the counterpart for the Commonwealth, for the ARCA, for the defense. So he works for Aperture. So he's going to be the equivalent, is my understanding, for the Dr. Daniel Wolf.
an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analysis. So we basically commissioned, if you will.
So the jury's already departed for the day. Look how the judge is acting. This is so unprofessional. It's an embarrassment.
ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 1230.
Well, it's no big deal, obviously, to her. What's the point of even making an argument? She's not listening.
138 to 1231/43 is as of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter.
No, she's
And
paid
also,
taking notes.
with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA. It's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffen's analysis. And Mr. Whiffen's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture. And we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it. And
Good.
so,
All
Your
right.
Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation.
So this Rule 14 thing that Hank Brennan was making a big deal about, trying to keep ARCA out and saying they destroyed text messages from over a year ago and all that kind of stuff. Hank's now got an expert that wants to completely change the timeline of when the supposed vehicle strike happened. And that's something that should not be done in the last minute. And that's something that Brennan was fighting over. And because defense has to be afforded the opportunity to rebut the government's witnesses, the government didn't disclose all the reports from their Aperture witnesses till recently in the last couple months, if I remember correctly. So defense is doing everything the way they should be doing to comply with the Rule 14 discovery requirements and deadlines. It's the prosecution now that's wanting to do something that they've been accusing the defense of doing, and they're the ones that have been guilty of it. So it's just really absolute hypocrisy here.
Remedy be that this is not allowed, and that the Commonwealth proceed with its the information of Aperture that has been extant before the May 8th date of the report. Thank you.
All right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ACA or have them go by their old report, right?
Right. And Your Honor, I'm going to answer your question, but with just a quick point that this is really much different than ARCA because two reasons. We are the defense. And
I bet you anything, Hank is the one that's trying to shepherd the expert to have their testimonies to line up. I don't think this Aperture expert would be changing his expert opinion unless it was for Hank Brennan trying to get him to do that by having him look at Whiffin's timeline.
ARCA is a rebuttal to the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you
Right.
have
So-
another
so-
option.
It's not what I am saying that I am proffering. I think the only remedy here is exclusion and a Rule 14 violation.
And you're not waiving that.
I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, a continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't, given what's been going on, I haven't even had a
Right.
chance to talk to ARCA at
All right,
all.
so tomorrow morning, let me know that. All right,
In Your Honor, I will do that, of course. And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffen, I had my whole cross-examination, not whole, but a significant part of my cross-examination
Right.
of Mr. Whiffen based upon going through human.
So they want to change their timeline again to say what window of time there was to have this vehicle strike, this phantom vehicle strike. So in a way, it also, I know it helps by them constantly changing the window. It also makes them look like buffoons. So, and on one hand, this could help them, but on the other hand, it's just like you have this last minute change of opinion. I really think this is some orchestration here by Hank Brennan trying to line up his different experts. That's what's going on here. I bet you anything.
Human volitional conduct off that phone that was after that 1162 trigger. And a lot of
I mean, think about it. Hank Brennan is the kind of guy that he keeps referring to this honorable defense attorney from New York City, Robert Alessi, by mispronouncing his last name. He's mispronouncing his last name throughout this whole trial, and you'll never stop doing that. Alessi, he keeps calling him Alessi. That's not his name, and he knows it. So he's just doing stuff to undermine and get under their skin. It's
of our defense in theory is based upon that's been in existence now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to your Honor's question.
All right, thank you. Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation. The Commonwealth, just like the defense, is entitled, continues to work on their case and study their case as time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. If you recall, in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time, given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as a witness they may potentially call. Mr. DeSorga wrote a report, and in the report, he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the texting data, the black box data from the car, has an event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review.
I think she's writing down what Hank's saying and not what Alessi is.
Their expert's report to see if he was accurate, that the variance means that these times would never align. And that's what he did. He studied the data, he studied the ways, he studied the Lexus black box.
Yeah, you impeach your own expert and said, "Hey, you're wrong. I'm going to lose here. You better line with my other witnesses here." There's a multiple minute variance that you're not accounting for. So you got to go back and redo your numbers. Otherwise, I can't even use you.
Relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned from his opinion is that Mr. DeSorga was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong. So then he looked at the time of the event of the ignition on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was.
He's just ranting because he's telling the judge how all these problems are happening now with his experts, that basically the defense experts was correct and his experts that he's presented now realize they're wrong. What are you going to do? Recall Whiffen as well?
Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moments when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text screen data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no delay. It's been a week now the defense has had this information. And so this is not
A week? You just gave it to him on the 8th. Today's the 15th. So, okay, I guess it is a week.
to align anything. While it may reconcile or identify that variance more closely,
They're still in the middle of the trial, Hank.
it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it is clarified and it is favorable for us. And so we should be able to use it.
Did you intend to use it in your case in chief or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce
In
it.
my case in chief, because we now have this available data. As I said, this wasn't ambush, isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now
So your timeline is all off based on what the defense says, and now you're basically trying to come up with a new theory. This is like so bizarre. So you want to come up with a new theory based on impeaching your own expert testimony?
now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay. Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information, and
Yeah, he did.
he has accurately provided information, but he's got the time completely wrong and the significance respectfully completely wrong. I'm going to hit his 4 categories quickly. He said, he referenced Mr. DeSorbo, who is a defense witness. Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert report within the reciprocal discovery deadline.
Okay.
And he provided that report months ago.
Okay.
So if, as I heard Attorney Brennan, he's saying the reason why we're getting something on May 8th is because Mr. Burgess supposedly is responding to that. That was months ago.
Okay.
The more apt point is, or an even more apt point is, Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DeSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A. So that's an important point with regard to Mr. DeSogra. Now I want to go to Attorney Brennan's comment about clocks are different. I agree with Attorney Brennan on that. The shortcoming for Attorney Brennan's argument, however, is that the clocks are different concept has been in existence in this case for over 6 months. I can give you by memory Mr. Whiffin's report of December of 2024, where his report went into the different clocks and what their significance was. So that is almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case. So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it. He already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of the first
All
trial.
right. I thought Burgess was, no?
No, neither.
Okay.
No one from Aperture was.
Yeah, I knew
Your Honor.
Aperture wasn't. I thought he may have been something. The name just sounded.
Neither
familiar.
Burgess nor Welcher were part
Okay.
of the first trial, but they were retained Aperture was retained, I believe, in October of 2024.
Okay.
And at best for the Commonwealth, Aperture had, and Mr. Burgess and Dr. Welcher had Mr. Whiffin's report that talked about the clock differences. So the clock differences cannot be, as the Commonwealth is proffering, some sort of new information that caused
There you go. Clarified as it's not new.
Aperture to provide a new report. This variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time. Mr. Burgess, in his original report months ago, has a whole section on clock drift. That's not a new concept for him. He's just changing the drift.
Okay. So what I'd like to do, because I want to address the other issue and I don't want to keep people here too long. Can you wrap it up, Mr. Alessi, or is that?
In 60 seconds.
Okay.
Thank you, Your Honor. Your Honor, the last point I wanted to make, and I think I heard Attorney Brennan correctly, is he said he was surprised that he got this report dated May 8th. That's what I heard. So if the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding fetching reason to not allow it, because they're surprised to get it. And I can lastly say this, Your Honor, there's nobody that's more surprised to getting this than the defendant when we got it on May 11th.
Okay. Thank you. The other issue about calling your expert on rebuttal, Mr. Brennan, based on the late disclosure of the ARCA materials. What's your argument on that?
I won't iterate the entire past, but Your Honor has found discovery
It's not late disclosure.
violations. Your Honor has found that I want to phrase this properly, the efforts of the defense were improper. And inevitably, we've now received an extraordinary amount of discovery on the most important issue in this case, well beyond the discovery deadlines, without any excuse. And the court, understandably, has overruled government suggestion and has stated that it's going to allow the defense to proffer two expert witnesses in a very complicated field, in an issue that is the heart of this case. If you're going to allow them to testify, despite the fact that we have not had adequate time to review, and to prepare, and to address it. The Commonwealth has the burden of proof. The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Wexler. As you know, he was away. He did not get a report until maybe May 7th. He did not have a chance to look at it until May 9th. An extraordinary amount of work, effort, and expense has gone into preparing our case for the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information, well beyond the simple four opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments.
True.
This requires not only review, but an analysis, testing, vetting, and then preparing testimony to address the claims made by the defense experts. Not to get into a battle of disparagement, but our expert has found extraordinary issues in his first reviews of material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate.
So your expert isn't even ready to go? He's still doing his own tests? He's not even ready to stand by his report that he submitted to the defense through you months ago? It should have been a lot longer than that.
The failures of these ARCA witnesses. That's going to take time. You've heard from the ARCA witnesses themselves. The the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks. We did not get the report until May 7th. And so we believe we are entitled to have our expert review all the materials, do his testing, provide opinions. None of that is going to happen anytime soon because he still has not finished reviewing all the materials. There's many, many gigabytes. He is in a difficult schedule. He is away tomorrow, Saturday. We were going to try to begin to prep at the end of the weekend. There is no way he's going to be able to testify anytime soon and have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what would we like to do is have him testify about what he has prepared, that he's had adequate time to prepare. If either of these ARCA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing the materials actively.
So he just always wants to have the last word in edgewise. He wants to constantly do the opposite of what ARC is doing, trying to rebut what they say. And so while the prosecutor does have a right to rebut something, he's going to always try to reinvent something new, whatever he thinks ARCA has the best advantage on with their testimony. So can the defense request communication between Aperture and the Commonwealth, much like Commonwealth demanded ARCA and the defense? Oh, yeah, I think there's a lot of stuff that they're not disclosing to the defense of communications. Think about how many potential experts they called around the country for trying to see if they would assist on this case. They probably got turned down on some, and they said that, no, we're not interested. No, it doesn't. We don't believe your theory makes any sense. So we're not of any service to you. Would that be noted down and put on some paper and given to the defense? Hey, we called these experts and they don't think they can help us because they don't think we have a case of this being a vehicle strike. So
he engaged his own testing now. So by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders. And so
yeah, he's still talking about violation of discovery orders. So he wants to continually make up this stuff so he can continually try to get his expert to put a spin and a twist on whatever he's trying to present in court. It's just so ridiculous. But you know what? With this judge,
so that he can
she'll
then
probably
address the jury on those
grant him his request.
issues. I see no other way of this expert fairly being provided, presented to the jury. The unfair prejudice cannot be cured in any other way. We ask that he be able to continue his review, offer rebuttal opinions on anything that is new, and not to encroach on anything that's been previously provided.
Can Burgess testify after Welcher?
No, because Dr. Welcher relies on Shannon Burgess' information material. It will make no sense. I thought about it. It makes no sense to the jury, his presentation, unless Shannon Burgess has an opportunity to provide the background information.
Right. Mr. Lessie, I'll hear you on this.
Thank you, Your Honor. I think and I understand that it's very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about ARCA and the information of ARCA, it's very important analytically to put them in their two proper buckets. The first bucket is the information and opinions of ARCA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on.
Okay, good, because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that. So
we're focusing just on the quote new information bucket. Your Honor, it's very important to understand that what ARCA is doing is in response to the testing of Aperture. ARCA did not come up with new approaches. We, again, to state the obvious, are the defense. We
ARCA already testified in trial one. Since trial one, the government wants to have their own ARCA-like experts because Trooper Paul is absolutely worthless for them in their case. They've realized that. And so they were delayed in getting this Aperture witnesses and their reports together. And because they're delayed, that pushed back the response and the ability even for the defense to hire ARCA, because they finally got released by the feds to be allowed to engage with the defense to be called as witnesses. So now they can talk to them openly. Before last year, they couldn't. And so in any event, these kind of messages that they had, it's really something that's more on the prosecution, their delays, than it is for the defense. So I think this judge is going to
Get to
whatever she can to
rebut
appease
what the
the prosecution. Hope I'm wrong on this, but ARCA is the thing that additionally breaks the back for the government's case. So Aperture, if they're changing their timeline now, that just shows you that they're not that great.
prosecution has put forward. And so what ARCA has done with the new information, new testing, is simply to rebut what Aperture has done. So I do not understand the length of time, or the lift, if you will, that's being proffered for Aperture.
Yeah, so if they got on March 26, that's not a lot of time for ARCA to respond, but they did respond, and they got it in by the deadline the judge gave them for the 7th of May, their additional report and testing. And now they want to do more testing. Aperture wants to do more testing, and then there's going to have to be time for ARCA to do testing to rebut that testing. And so really it's the discovery rules have deadlines for a reason, and the prosecution should not be able to get over on the defense's way by running out the clock.
Now with regard to the time period, Your Honor has already determined what the appropriate approach is for the new information from ARCA. When Dr. Rentschler was on the stand, and Dr. What you said, when can you get me the information? And they said, I think it was May 6th or May 7th, whatever, and they met the deadline. They did it. We proceeded along with the trial with that information. We complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided. I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to continue to address this matter as if the defense is making perpetual violations. There was a determination made, and then the question was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing violations. My final 2 points. What Mr. Brennan is seeking is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things, have ARCA have to come on, and then have Aperture come back and essentially have almost a rebuttal to a rebuttal as of right. I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices the defendant, right, because it almost ipso facto gives a double rebuttal, surrebuttal to the defense. I believe, Your Honor, the final point is, if Your Honor is inclined to give Aperture more time, and I haven't even heard a deadline yet for Dr. Welcher. It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude its review of the ARCA work, and that there be a reflection that keeps the order, namely that the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
All right, so I have a question for you, Mr. Lessie. Are you still thinking that if the defense puts on a defense that will take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And not holding you to this because obviously you have no burden. If ARCA is part of that defense, when in that week and a half time frame would that be?
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay. All right. I needed all this information now, so I appreciate it. All right. Thank you.
Court, all rise.
Back up.
Goodbye.
Court,
Pretty close that it would be toward the end.
Okay. All right. I needed all this information now, so I appreciate it. All right. Thank you.
Wow, look at that
all
slamming.
rise.
Toward the end.
Okay.
Look at Brennan's left
All right.
hand.
I needed all this information now, so I appreciate it. All right. Thank you.
Court,
He's not
all
happy.
rise.
Goodbye.
Well, I remember that the Aperture witness, I forget which one, but there was an Aperture witness that had said he was on vacation, didn't really have much time to really look at whatever ARCA had submitted. Hold on a second. I'm going to go back. Stand by. You guys have to see some of the prior doctor's testimony. So I want to go back. It's at 6:29:35.
That
There we go.
picture.
Do you have any information on the circumstances which led to that condition?
I do not.
Do you have any information about what caused the condition that you saw on that chart?
I have seen similar pictures in textbooks depicting gastric hemorrhages or Wisniewski spots.
Yes. Anyway, I'm just thinking about that. So Hank Brennan, he wants to get in the last time frame, his expert in, so ARCA doesn't have the last word in edgewise. That's what he's trying to do. So they can't have any test to rebut it or anything. So it's going to be something that I think is just going to not matter in the end because he's already lost his case. Aperture isn't going to save his case. He's already changing the time frame now. So even if they get the last word in edgewise, it's not going to matter. I think the judges has no ability to control any timelines and hold their feet to the fire for the prosecution. It's all what can I do to help the prosecution and the defense be damned. So it's not going to matter in the end. That's how I'm looking at it. I'm not going to get too upset about it because in the end, they're continuing to make fools all over themselves, and they can't shoot straight. And when you don't have the truth on your side, this is the kind of tactics you have to resort to. All this money they're spending, wasting the Commonwealth's money. And if Hank thinks really an expert after today is going to save his case, it isn't going to happen. It isn't going to happen, folks.
You were asked about your role as a medical examiner, and there were a number of questions about your assessment from a legal perspective.
Yes.
You mentioned that you had information from a police report. How many police reports were you given?
There was a preliminary police report, I believe, the day of the autopsy, and communications with law enforcement in the days and weeks following.
May I approach?
Yes.
Showing you a document. Do you recognize that document?
Yes.
What is it?
This is a police report on this particular case.
Is that a police report from your file?
Yes.
And that police report, is that the police report that you considered?
Amongst other information, yes.
How many lines is that police report?
11.
What's the date and time of that police report?
This was initiated on January 29th. It says at 1941.
I have this marked for identification, Your Honor.
Okay.
And in the, what's another document?
Let us mark it.
Oh, sorry, let me have that back.
Yeah.
Q for identification.
Yeah, so if they want to expand the window, let's say to 12:40 something, we already know she was home by 12:36 at John's home anyway, so we know that is actually helping the defense. So one second, I'm going to check something here on X. So anyway, all right, nothing there that I want to share with. Maya Rodriguez Sorensen, Esquire. Yes, I think the full acquittal. Hung jury is at least it's not a conviction. Yeah, she deserves full acquittal. Yeah, I just sure believe that, folks. When I've had my opponents doing shady, dirty stuff, I just always believe I'm going to be able to call them out on it in front of a jury, and a jury is going to see it for what it is. And I've never had a problem with that. And when they're this underhanded and shady about stuff and trying to trick the jury into believing all these different false theories, these changing false theories, I just never had a problem with that in any of the cases I've argued. So, and these guys are sharp, they're good. So I don't see that being the case again. I don't think we're going to have a cop on the jury again that's going to trick these jurors into discounting everything the defense did. I just don't see that happening this time. You're saying their drive is 6-7 minutes good, we're completely sober. Yeah, there was what is it, Las Vegas cops guys I saw on YouTube. They did a drive. It was like over 7 minutes in good weather. So if she got there, yeah, she would have left there by 12:29. So they don't have a case either way. So I don't know. I don't know what Brennan's thinking. Otherwise, he's a throwing the towel.
Yes.
Second document, is that another document in your file?
Yes,
And is that another report that you considered?
yes,
How many lines is that report?
5.
Let's move to have this marked for identification, please.
Okay.
Thank you.
Exhibit RR for identification?
Yeah.
Can I approach again?
Yes.
I'm gonna go back to the questions I asked you about logging in and refreshing your memory.
Mhm.
I'm gonna hand you the document. I'm not gonna actually read it aloud, I'm just gonna ask you to look at it. Does it refresh your memory on the people who attended the autopsy?
Yes.
And who were they?
I believe one person was Mr. Keefe and the other one was Mr. Corner.
Are you part of the criminal investigation team?
No, I am not.
Did you go to the scene and evaluate any evidence?
No, I did not.
Did you do any of your own detective work or investigation in this case?
No, I did not.
So when you were asked questions about your role,
Like he's cross-examining her. He's doing so much leading on his redirect. I would shut him down if I was defense. It may not matter with his judge, but I would object.
as the medical examiner in your medical evaluation of Mr. O'Keefe's body, you were also asked whether you considered any part of the legal aspect. Do you remember those questions?
Yes.
You would never, well, let me ask you. You submitted the death certificate on April 14th.
Correct.
I want to talk about some of the things that you may or may not have known about or considered at the time you wrote your death certificate or filed your death certificate. Were you informed or were you aware that before you filed your death certificate, there was information in the investigation that police spoke to a first responder by the name of Timothy Nuttall, who reported that the defendant
I'm going to allow it.
said, I hit him, I hit him, I hit him.
What?
You
So the judge allows this in, the I hit him aspect, to try to get her to change her mind. What about the fact that there was the dog bites and there's the dog in the house and the dog had all these that was not barking when all this was going down with the cops showing up. So where was anyway, you could go on and on with this and let's see what happens.
aware of
here.
that
I became aware of it at some point.
during your 90-day window?
I believe so.
Were you aware that there was another first responder by the name of McLaughlin?
This is like so weird. So that's what they're going to do, is look at a police report like that. So an admission by the suspect is going to be what carries the day on what otherwise doesn't meet medical standards.
Who provided information that
Cause
the
of manner of
defendant said,
death?
I hit him, I hit him, I hit him, I hit him?
Yes.
Were you aware of statements made by the defendant, to Miss McCabe, that she said, may have I hit him? Did I hit him?
Objection, our may we approach, please, briefly?
Yeah,
Okay.
good. It's ridiculous.
Thank you.
All right, hold on. This one here on Boston 25, it goes dark for a little bit here. Let me see. No, that's not it. Okay. That's on the recross of Alessi. Stand by. So I'll just fast forward.
So that So jurors, I want to let you know that like other evidence that was let in previously, this is not coming in for the truth of what's in the statements. It's coming in so that as it goes to Dr. Scordi-Bello's knowledge and state of mind at the time of her report.
Thank you. At the time of your death certificate that you filed, were you informed that a Jennifer McCabe had reported that the defendant said, did I hit him or could I have hit him multiple times?
Objection, Your Honor.
I'm going to allow it.
What about the context for all this? We're going to get into the battle of the context and the motives and all that kind of stuff. I mean, it's you open up a can of worms here, Judge, but of course you'll close it from the defense being able to bring out all these points.
I don't believe I knew about Miss McCabe.
Did you learn that Ms. McCabe reported later that the defendant, while speaking to first responders, reported that she had hit him? Did you know that?
I was aware of that information later on.
Were you aware of the investigation regarding alcohol consumption?
Yes,
Were you aware that the police or Massachusetts State Police spoke to other witnesses about their observations that night?
about their,
Their observations?
yes,
Were you aware
Yeah, of course they're trying to offer this for the truth in the matter asserted, the hearsay statements.
of an interview by Trooper Buchanan with firefighter Daniel Whitley on February 7, 2022?
I don't remember.
Were you aware?
So he's trying to impeach his own expert. Isn't that bizarre? He's coming across like a bully. So let these young jurors see him for the bully that he is.
That Mr. Whitley told the police that the defendant had expressed that she had gotten
This
into
is not how you have a medical examiner testify at a murder case, throwing in all this hearsay stuff. So bizarre.
an argument with the defendant that night?
That was part of the information I was given, yes.
Were you aware of a report from first responder Anthony Flamate about statements made by the defendant to him?
I don't recall that particular first responder, no.
Were you aware of statements provided by Kerry Roberts to the police that the defendant had called her, citing Kerry, John is dead,
Yeah, I was given that information,
Good.
and the questions of did I hit him? Were you aware of that?
yes.
Were you aware of information that troopers had an opportunity to go and speak to the defendant?
Yes,
Were you aware of the statements that she made to the troopers?
not in detail.
I don't know. This is Boss 25 went dark. At least we got sound.
Were you aware that when they spoke to her on January 29th, she informed that she had a broken taillight on her vehicle but did not know how it happened?
Objection, Your Honor.
I'll allow that.
Of course you will.
Yes, I was provided with that information.
Were you provided the information that she had never observed John enter the residence?
I believe that was part of the original information, yes.
Were you aware that she informed relative to the broken right taillight, she didn't know how it happened?
Yes, I was.
Were you aware that members of the Massachusetts State Police obtained John O'Keefe's phone and did a forensic data analysis on it?
I was not aware of that until much, much later.
After you filed your report?
Correct.
Were you aware?
Are you aware that Karen Reed has an alibi that shows she couldn't have been there at the time that I'm telling this jury that the vehicle strike happened?
Of location data that was obtained from John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of healthcare data on John O'Keefe's phone before you filed the death certificate?
That's what I'm saying. If you're tone deaf as a trial attorney, you don't understand how you're coming across to the jury. Guys like Hank Brennan, they don't get it. They just have their own mindset. They don't read a jury. He's sitting up there in his chair. He's looking straight ahead. He's not paying attention to how he's coming across to the jury. He's walking back to the lectern there to be able to do his scripted questions, and he's just thinking that the jury's just believing everything he's saying, I think, for the most part. But he's got to understand these witnesses are just bombing for him right and left. They're not helping him build his case. He's not established a single element of any of the charges yet.
Okay.
No, I was not.
Were you aware of battery temperature data on Mr. O'Keefe's iPhone before you filed your death certificate?
No, I was not.
Were you aware of voice messages left on John O'Keefe's phone from the defendant before you filed your death certificate?
No, I was not.
Were you aware of text messages between the defendant and John O'Keefe before you filed your death certificate?
No.
Yeah, so the jury's got to be sitting there. What's this guy doing? This is taking our time, and you're sitting there trying to bash your own witness over the head because you're just basically an angry little bully that's so mad at this witness because she's basically just blown your case out of the water.
Were you aware of statements from the defendant to various media outlets?
I mean, this is so leading as all get out. Yeah, this should not be allowed in a real court of law. All this leading, super leading redirect would not be allowed.
Yes. Before you filed your death certificate?
No, I was not.
Did anybody ever come to you after you filed your death certificate and ask you to change it?
No.
Did anybody ever provide you any of this additional information you weren't?
Did anybody know? Did you know that the lead detective on the case called you a nut job?
Aware of at the time, asked you to evaluate it, and then reconsider your finding?
No.
Yeah, redirect with all this yes, no. This is not the way it's done, folks.
You were asked some questions about impact injuries. In your experience, are most pedestrian collisions where there's injuries to the lower legs, either frontal or rear impacts?
Objection, Your Honor.
I'll allow that because I'll allow that.
Most pedestrian fatalities that we see are
You tell me the younger jurors aren't going to think this is bullying tactic. I would think the jury is absolutely sick of this guy, and they can't wait. They can't wait for him to stop talking. He's lost the case, and he's lost the jury. He can't read evidence. He can't read jury members, and that's how you lose a case.
with impact with the front of the vehicle.
When you gave the perspective that you looked for impact injuries, was that with consideration of your experience that most collisions are frontal impact injuries?
Most collisions involve frontal impact, yes.
How about cases where you've had an opportunity to observe people who sustained injuries
Can you imagine ever getting in an argument with a guy like Hank?
from being clipped? Not hit, but just being clipped. Is your
Can you ever imagine any kind of competition with Hank Brennan, how he would treat you?
opinion any different in your experience?
Objection, Your Honor.
Sustained in that form.
How about a side swipe injury? Is that different relative to your expectations to lower
I really wonder if she's aware she was called a nut job by Proctor.
extremity injuries?
Objection, Your Honor.
Sustained.
A bruise on the knee, is that consistent with a side swipe impact?
Could be.
Did you do any type of biomechanical analysis of any alleged collision in this case?
No, I did not.
That's what you guys were supposed to do, Hank. Oh my gosh. You had all this time to have the state do biological testing on all those pieces that you supposedly found at the scene. You didn't do any testing because you know they weren't striking John's body. That's why you didn't do any testing, because it would have cleared him and from not having made any contact with that vehicle.
Were you asked to?
I'm not qualified to do that.
And so when you talk about injuries from a collision, are you in part speculating about what could happen to somebody?
Objection, Your Honor.
Sustained in that point.
Are you giving a direct opinion in this case about how?
This is so ugly what he's doing to her. It's really ugly. It's ugly to see and watch. And this is what a loser prosecutor does. It just gums up the whole case, just starts slashing and burning and acting like a little angry child here.
The injuries were caused?
Objection, Your Honor.
Sustained.
You were asked questions about a nose laceration.
Yes,
And you offered that was not consistent with falling backwards on the head alone.
correct,
You were asked if that was consistent with a punch.
correct.
Objection, Your Honor.
That's not the testimony. That's your objection. Mr.
That
Witness.
is
Yeah, see, right there, you were asked if this is consistent with a punch, and you objected to it, and she didn't allow it. The judge didn't allow it.
there's not a question.
Did you provide an opinion that it could be consistent with a punch?
I did provide that opinion.
Could it be consistent with broken glass?
It's possible.
Could it be consistent with sharp shards from broken plastic?
Possible.
Could it be consistent with first aid?
I'm sorry, what was
Could
it?
it be consistent with first aid treatment?
Anything is possible.
Wow. Do you have any firsthand knowledge of how the laceration on the nose happened?
I do not have firsthand knowledge.
Okay.
Did you know at the time you filed your death certificate that there was plastic pieces of taillight found near Mr. O'Keefe's body
I don't know what
around
I'm doing. Hold on.
5:45 p.m. on January 29, 2022?
I do believe some of that information was communicated to us, yes.
Thank you.
All right, Mr.
Oh, I'm gonna stand by. I'm gonna get rid of this Boston 25. Here we go.
Thank you, Your Honor.
All right.
Dr. Scordi-Bello, this
Here she is after getting verbally abused by Hank Brennan, trying to make her look like an idiot, trying to get her to change her mind, but she's held her ground. So
Attorney Brennan just
Great
asked you
talk.
questions about alcohol consumption. You had the opportunity to evaluate the medical records of Mr. O'Keefe, correct?
Correct.
And you had, in terms of the medical records, information with regard to the medications that Mr. O'Keefe had taken. Is that correct?
I believe I reviewed those records at some point prior to issuing my report. Yes.
Do you recall the list of medications that were in the medical records that Mr. O'Keefe was on?
I do not recall.
If I were to show you a document, might that refresh your recollection as to the list of medications?
I'm going to allow it. Is in connection with alcohol too, you said, right?
Correct, Your
Go right
Honor.
ahead.
Yeah, Coach, Your Honor.
Yes.
Dr., may I, Your Honor?
Yes.
Dr. Scordi-Bello, may I stand by the witness here?
Yes.
Thank you. Dr. Scordi-Bello, I am providing you with a document. Up at the top it says John O'Keefe, and I would like to draw your attention to medications. And to expedite it, I am going to focus on the fourth item on that list. Can you state what that medication is?
The fourth item is omeprazole.
Does that refresh your recollection as to one of the medications Mr. O'Keefe was on?
Yes.
And that medication is,
It's an antacid.
right, and so omeprazole is the trade name of omeprazole Pepsid?
I believe so.
And Pepsid is a proton pump inhibitor?
Correct.
And a proton pump inhibitor stops the proton pump in the stomach from releasing acid, correct?
Yes.
And we're going to come back to that in just a moment, but do you also recall testifying at the grand jury with regard to alcohol consumption and potential alcohol consumption of Mr. O'Keefe?
I do remember testifying. Yes.
And do you recall what your testimony was with regard to alcohol consumption and small ulcers in the stomach potentially associated with alcohol consumption?
Alcohol consumption, I don't recall my exact words at grand jury, but alcohol consumption can lead to gastric ulcers.
And alcohol consumption can lead to gastric ulcers. And what medications can treat gastric ulcers?
Well, they don't treat them, they prevent them, but
I think she does think this case is a joke. Anybody living up there, I'm hearing you can't go anywhere without people thinking that Karen's been railroaded. So how they think they're going to get 12 jurors to convict?
that would be a proton pump inhibitor such as omeprazole.
Right. So, isn't it correct, therefore, that the ulcers that are observed in the stomach of Mr. O'Keefe that we talked about, the gastric mucosa, could have come from ulceration due to alcohol consumption,
It's possible.
as opposed to hypothermia, correct?
Correct.
Should have sat down on your redirect.
Attorney Brennan asked you questions moments ago, and actually several of them, of which included the words, did I hit him? Could I hit him? Do you recall those questions?
I do.
And isn't it correct that you had that information before you issued your final findings in this matter in April of 2022?
Yes, I did.
So, even though you had all that information, you still were unable to conclude the manner of death of Mr. Keith, correct?
Correct.
Wow. Thank you, Dr. Scordi-Bello.
All right.
That's what happens when you have an attorney that treats a witness, professional like her, with dignity and respect that she deserves. You don't lose yourself with your anger and just go off on her about all the stuff that you're trying to get her to change her mind on. So anyway, it's a good lesson learned kind of training if any of you out there want to be lawyers. You do not want to be a lawyer like a Hank Brennan, where you have no credibility in front of a jury. You want to be someone like Robert Alessi, who has the utmost respect and credibility in front of a jury. And it shows your personality and character shows in the way you question witnesses, the way you handle yourself in court. And like I say, credibility is the most important thing you bring into the courtroom. And if you don't walk out with credibility, and you never had to start out with, then you're gonna tank your case. Even if you got a winnable case, if you come across bad and you're not credible and trustworthy, you can still lose a case that way. So here you don't have facts, you don't have credibility, and what the prosecutor's doing is underhanded tactics, and he's acting like a defense attorney, and that doesn't win being a prosecutor. So with that, it's 12:43 here. So I'm going to go ahead and sign off, and hope to be back tomorrow night. Y'all have a safe one. Hope to see you tomorrow night.